Good morning, everyone. I guess now it's good afternoon. It is 2 minutes after noon. Welcome, everybody. My name is Tom Nagel. I'm the chair of the Maryland State Advisory Committee to the Commission on Civil Rights. And before we get started, let's introduce the other members of the committee that are here. Pamela, will you start? Please introduce yourself.
Sure. I am Pamela Bennett. I'm a relatively new member. I'm an associate professor of sociology at the School of Public Policy at UMBC.
So let's just introduce names so that we know each other's names around the table. No need for background. Okay.
Tara Huffman.
Jennifer Mathis.
We're members of the committee.
Doris Cowell. Jenny Segura.
George Lanoux.
Greg Dolan. Tracy McComb.
Okay, thank you. And then we also have some folks here on behalf of the U.S. Commission on Civil Rights. So,
Barbara DeLaviz, I'm the Eastern Regional Office, and with, if I may, we have Ivy Davis here. She's the director of the region. We have Amy Royce, is David Claddy's special assistant. Ruth Kusingla is Chairman Catherine Lehman's special assistant as well. She's new to the commission and wanted to be here. Unfortunately, she's unable to attend, but hopefully we'll be speaking with the Maryland members soon. And I'm sorry, last and certainly not least is Eric Japil. He has been helping the commission in a variety of functions with SAC activities, Connecticut, Maine, and now Maryland has the good fortune of having him here helping us as well. Thank you. Thanks everybody for coming. Thank you all, and we will introduce the panelists in due course. I do want to say that this matter is being live streamed today and recorded. And just for background for everybody, the U.S. Commission on Civil Rights is an independent, bipartisan, fact-finding agency established by Congress to collect information relating to discrimination or the denial of equal protection of the laws under the Constitution based on race, color, religion, sex, age, disability, national origin, or in the administration of justice, to inform the development of national civil rights policy and to enhance enforcement of federal civil rights laws. The Commission has established state advisory committees to advise about civil rights matters in the 50 states and the District of Columbia, and the Maryland State Advisory Committee is one of those bodies that has been established. The purpose of today's roundtable is to gather information on the use of fines and fees in Maryland, as well as to better understand the implications of the recent Maryland Court of Appeals decision regarding bail reform. Now, before we proceed any further, there are some thank yous that are in order that I want to acknowledge. First of all, we are grateful to Morgan State University for enabling us to use this facility, and in particular to Pace McConkey, one of the committee members who has arranged for the space that we have today and for the commission. So thank you very much, Pace. I'd also like to thank specifically the members of the subcommittee that have focused on this particular topic and arranged for the panelists to come today. Pamela Bennett, Tara Huffman, George Lanoux, Ernie Dominguez, who could not be with us today, Doris Cowell, and Jennifer Mathis. Thank you all so much, and we hope that you'll see your work blossom fully today. To help us better understand the issue, we have invited, and the task force in particular, has invited knowledgeable persons with a wide variety of experiences and viewpoints to share information with us. And there will be, I believe, 3 separate panels today, the first on fines and fees, the second on bail reform, and the third on bail reform. At the outset, I do want to remind everyone present of the ground rules for the briefing. The meeting is open to the general public and to the media, and the proceedings are being live streamed. In order to accommodate the full schedule that we have, each presenter will have 12 minutes for their statements. After all the presenters on a specific panel have made their opening statements, we will have a question and answer session with advisory committee members. I will ask members to be mindful of their colleagues with a limited question, to limit to one question until all members have had a chance to ask. And depending on the time remaining, and we'll recognize folks in the room for additional questions. We do understand that viewpoints presented today are neither exhaustive nor all-inclusive, and some folks may find statements today to be controversial or perhaps not consistent with their viewpoints about issues. But this needs to remain civil, and we want to be sure that nobody is defamed or degraded in the process, and we expect that all opinions will be welcome and the presenters all treated with dignity and respect. And of course, anyone who feels as though they've been defamed or degraded by statements made during the proceedings should inform the commission staff so there's an opportunity for a public response. In addition, persons and organizations may file written statements for inclusion in the proceedings. We are certainly grateful to our presenters for your willingness to share your views today, your experiences, and your expertise with the committee. And on behalf of the advisory committee members, I thank you all for your engagement in this roundtable. Your willingness to participate speaks to the importance of the observance of civil rights in our society, so thank you again. Recording of this meeting will remain open until May 25, 2017 for anyone who wishes to submit a written statement. And with that, I am going to welcome our first panel and begin with our presenters. And Judge Stephen Speakus is here, Nick Steiner with the ACLU of Maryland, and Douglas Colbert from the University of Maryland School of Law. And I would ask if Judge Speakus, if you would not mind being our first presenter today.
I would be happy to. I note, by the way, that this identifies me as a former judge. I was not removed from office. I did not resign under fire. I am technically a senior judge. I turned 72 months ago, and under Maryland Constitution, sadly, I am now senile. So take everything I say with a grain of salt that I'm constitutionally senile. So anyway, yes, I'm a senior judge, which means I'm still serving as a judge, but I serve now part-time. Now, I want to make clear, before I begin, that I'm speaking now as myself, as a citizen and as someone with a special range of experience. I'm not speaking on behalf of the Maryland Judiciary. I'm not speaking on behalf of the Baltimore City Circuit Court. And I would also note that my experiences, what I'm going to be talking about, is not the result of the kind of deep research in the law that some of the professors and academics here have done, but is rather my experience as a practitioner, if you will, in the courts of what I have seen happening in my impressions and the many people I've dealt with. I would note that when I began, my career was in civil law. I represented healthcare institutions back before I went on the bench. And when I went to the bench, I had no prior criminal experience. And I inherited the caseload of the judge who had been what we call reception court judge for 10 or 15 years in a row, which means I inherited all of his probationers, 3,000 probationers. I probably had more probationers, I believe, than any other judge in the state with no criminal experience. I learned about the criminal law from the back end first, from the post-conviction time, rather than seeing it from the beginning. And so that made me very conscious of all the issues relating to re-entry, rehabilitation, how one sentences appropriately, all the policies involved in it. And then I rotated into juvenile court, and I spent several years in juvenile court. And I wanted to say, most people are not aware of this. At any given moment, there are 3 separate criminal justice systems that apply in the state. There's the federal system, which you know about. There is the state adult court system. And then there's the juvenile court system. The juvenile court system is a different thing. There are no fines in juvenile court. There are no fees in juvenile court. And incarceration is heavily discouraged. In fact, you can't really incarcerate someone in juvenile court. You can hold them, you can send them to school or something for maybe a year, 18 months to outside. It's a very different experience than the ordinary criminal process. It had an enormous impact on me, and I'll explain as I go through my talk. Now, the topic of today is fines and fees, and Professor Manu and I had some chats about fines beforehand, and I explained to him, I really don't know what one does with a fine because I've never fined anybody. Remember, I'm at the circuit court level, and I did some checking, and I found that virtually none of my colleagues, and I asked, and maybe others who do, none of my colleagues essentially fine anybody, and I consulted with the State Attorney's Office and the Public Defender's Office. It is not common for people to be fined in the circuit court. I believe are fined more frequently in district court, and I've never served in district court. That, at least for the more serious offenses, the offenses that are most likely to put you in jail, tends not to be a pattern. Where I would have considered, and others would have considered a fine, what we typically would do would be community service. And community service, people have different amounts of money, but we all have exactly the same amount of time. Right? 24 hours is 24 hours, whether you're rich or poor. So the community service obligations are much more commonly used than fines. The State Attorney's Office almost never asks for fines. The Public Defender's Office never suggests them. So that seems, at least in my experience in Baltimore City, that grant is different than other counties, and maybe different in Montgomery County or Somerset or wherever. But that is most likely true, I think, in most of us at the circuit court level in Baltimore City. But there are fee issues, and these are very significant and very problematic. So I want to address most of my talk to the fee question. And I want to focus on two particular things, given the amount of time I have. The first is supervisory fees for probationers. And the second is something that I think will be relevant in the discussion later on about bail reform as well. And that has to do with the ability to make use of modern technologies to supervise people. Let's talk for a moment about the supervisory fee. I was stunned to discover that the parole probation charges $40 a month to anybody who's on probation. $40 a month. For most middle-class people, $40 is not a whole lot of money. You might blow that in Amazon on a whim, okay? But it's $40 per month. The typical probationary period in Baltimore City is 36 months. So $40 a month times 36 months is $1,440. And for the person who's on probation, remember, if you are on probation, number one, the odds are pretty good you don't have a lot of money to start with in the world. Number two, it is an obstacle for jobs. And certain categories of jobs really are out of reach. So therefore, the $1,440 ends up being a significant burden on many people. For more serious offenses, sometimes we have 5-year probationary periods. And the law does not permit you to go beyond 5 years, except in two circumstances. One, you can go beyond 5 years for purposes of restitution, and sex crimes can go beyond 5 years. But basically, no probation can last more than 5 years. But again, think about it for a moment. The 5-year probationary period is about $2,400. This ends up being a significant issue. What does one do? Well, here is the problem. The failure to pay the supervisory fee is in itself a violation of probation. So you now have an impossible fine or fee to pay, or a very difficult fee to pay, and at the same time you're trying to find a place to live, and maybe you have children or whatever, and you have this additional burden. And it is a violation of probation, which means you could be jailed for it. So that's problem number one. My impression, this is anecdotal, is that very few judges will revoke their probation or effective probation just for the failure to pay the supervisory fees, but at least it's a theoretical possibility. The second possibility is that at the end of the probation, the person hasn't paid the fee, in which case you send the case off to Central Collections. This is the collection agency of the state. Now, they will charge, they'll tack on a 17% collection fee when they file a suit to collect money. They collect everything that anybody who owes the state money goes to Central Collections. For the 3-year probation, that'll be an additional $245 for a grand total of something like, what, $1,668, and for the 5-year probation, it's an extra roughly $600. So we're looking at $3,000. So that just compounds the cost. Now, there's a third alternative, that I now find that I have always done, and most of my colleagues apparently do as well. The judge has the authority to waive the fee. You routinely waive the fee. Now, the judge who doesn't waive the fee, again, can jail the person for consent collection. Most times it's waived. Now, how much money in a given year is collected through supervisory fees? I think George had, Professor Lemieux, I think, mentioned to me something, $300,000, something like that.
That came up in our research, but I don't remember the source now. Maybe the Brennan report.
So let me just say, in the great scheme of things, it is a trivial amount of money for the state, but a substantial amount of money for the defendants. Now, there are those who would say, they brought it on themselves. I mean, so there's some, but the goal at this point, in a probationary period, is not to continue the punishment. The purpose of probation is to allow someone to change his or her life so that they no longer are problems in society. It is a chance that we give them to earn their way back into citizenship. And anything that's an obstacle to that, to me, is a major problem. This is bad social policy. And I do not know of any argument, strong argument in favor of it. It does not collect lots of money. It is largely uncollectible. It puts people in jeopardy of violating probation under circumstances in which they really have no opportunity to do anything else. So that, to me, is a significant issue. And by the way, they have an uncollectible judgment against them, which allows the state to garnish wages, ruins credit rating. It's an obstacle for them to rehabilitate themselves and to get back into society. Okay. Here is an even more important issue, something that I learned about in juvenile court, and this actually has relevance to the bail issue as well. We are a very technological society, and among the things we have are GPS devices and electronic monitoring is a possibility. In juvenile court, there is no bail, and we make regular use of something called house arrest. We turn their own home into a prison, in effect. And it's enforced not by random visits by probation agents, it is enforced, rather, by the fact that they wear a bracelet, and when they leave the house, except for specified purposes and times, it'll set off an alarm. Now, we use that in adult court as well, but here is the problem. The state does not pay for it. In juvenile court, the state does pay for it. It is used every single day. There's probably several hundred people in this city at this moment wearing bracelets. But for an adult, particularly as an example, someone who's actually holding a job, or someone who actually has children in the household, or is taking part in society as a normal person, but who runs afoul of the law in some fashion. This is an alternative to jail. It's an alternative to a great many other things. And what I would typically do is I would say, and this is actually pretty standard, you can leave the house to go to work, to go to the doctor, to go to your probation agent, to go to court, to go to church, and 4 hours a week to get a haircut or other kinds of errands. And basically, that really constricts you. You cannot leave the house to go to the movies, go down the street and visit with friends, to buy an ice cream at the corner. You cannot do that. You can do all these functional things. They are in prison, but they're in their household. By being in their household, they do not lose their job, they do not lose contact with their children, they do not lose their role in society, they can still go to church if they're churchgoers, they remain integrated into society in some way, and yet they are under close supervision. And if they cut the bracelet off, what happens? Alarm goes off, and we know exactly where they were at a point in time. And when the sheriff goes out to try to pick them up, you know where they started at, it's easy to pick them up. This obviously is an alternative for bail as well. If I could put everybody on GPS, I would never grant bail to anybody. I put them on GPS. It's so clearly superior to any kind of bail system that there is. Why do we all do it? The answer is simple. They pay for it themselves. $15 to $20, depending on the company, $15 to $20 per day. $450 to $600 per month. $4,800 to $7,200 per year. Even for middle-class families, this is an ouch. So what ends up happening is, if you are thinking of putting someone on a GPS, or in a GPS, unlike house arrest, we simply know where they are at all times. Right? They're satellite, we know where they are. To put them on either GPS or house arrest electronically is out of reach financially for the great majority of defendants where it might be a useful device. So the result is that people end up going to jail who may not need to go to jail, or people are put in a less highly supervised probation than I think is warranted or would be warranted by the circumstances of the offense and the personal circumstances. This is an easy solution. And it frustrates me, and I've raised this issue a million times and no one does anything about it. I hope you guys will think about it. If the state were to pay for this in lieu of putting people in jail, which the incremental cost is about $10,000 a year, right? If the state were to provide this, the state would actually save money. There is no good purpose for the state not paying for this. And in juvenile court, we have this counter-example of a system in which they never use bail, they don't use jail, and yet people are highly supervised and controlled. To me, this is a very powerful alternative for adult court that is not used. It is also a powerful alternative to the bail system. The bail system, I pay my money and I walk out of court, I'm a free man, I can show up at court, but instead of being a free man, I speak bail and I go to Chicago. Okay? Or I go across the border into Canada or something. And we won't know that you've gone until you don't show up in court. With the GPS, if you cut off the bracelet, we know you're gone that moment. With the GPS, if you cross the state line, we know that you crossed the state line that moment. It is so much cleaner, and yet the person can go free, and we don't have to worry about many of the economic issues if the state is paying for it. The state does not pay for it. To me, that is so clearly a wise investment of the state's money that would actually eliminate unnecessary incarceration for a category of persons. There are people who are going to go to jail with respect to those horrible things. We know that. There are people who are going to be on unsupervised probations because that's the appropriate thing. But there's this intermediate stage that we could use this as a good device to keep people out of jail, to keep people connected to their families, to keep people working, and yet at the same time under close supervision so that we know what they're doing and we know where they're going. So, to me, that is good. Am I done? Bingo, I'm done. I'm over.
Thank you. Mr. Steiner.
Yeah, so I printed out just a little outline of what I'm going to talk about. If you want to look at it, I guess I'll just start while that's getting passed around so we don't waste any time. But so I guess the first thing that I wanted to say was I by no means am an expert in this area, but what I'm going to present, and hopefully it's useful, is some of the information that the ACLU of Maryland has collected by doing court watching and also talking with the Public Defender's Office and public defenders across the state and kind of getting their opinions about what they're seeing. And so I guess the broad stroke conclusions are that at least the waiver of fines and fees is very judge specific, meaning it depends on the judge whether or not a fine or fee is waived, and it's up to them whether it's waived at all or if it's imposed. And so that non-uniformity in how those fines and fees are assessed is problematic. So one thing that is kind of a procedural way of preventing an individual who can't afford to pay for that fine or fee is to have a show cause hearing. And so maybe Judge Stevens can talk about these show cause hearings a little bit more because I'm not as familiar as he is probably. But basically it's a hearing where the judge will be able to hear from the defendant his financial circumstances and whether or not that fee should be waived. So specifically I wanted to talk about cases involving child support and what we see in traffic court as well. So with child support, there's child support and I guess restitution are two areas where people are actually jailed for non-payment. And so one example is this guy that we spoke with, Michael K., who had $9,000 in unpaid child support payments, and that was mainly because he was struggling with an opioid addiction. And so he was arrested. The bail bond amount was set at $400 for him to get out, and oftentimes that's a lot lower than what we see in other cases with child support, where the actual bond amount is the amount owed. So if the person can't afford in the first place the total amount of child support, there's no way he would be able to support the bond to get out of jail. And so this guy, Michael K., he went into jail, and 30 days passed, and he's asking to see an attorney, but nothing happens. 60 days pass, nothing happens, and finally he meets with a public defender, and by 70 days in jail, he's released. And basically, he spent this 70 days in jail because he couldn't afford the $9,000 of unpaid child support payments, which accrued over time, but he was never afforded a show cause hearing, so he couldn't explain that he couldn't afford it. And so after those 70 days, he finally got his show cause hearing, and the show cause hearing is scheduled in May, so it hasn't happened yet, but presumably in that hearing, he'll be able to explain that he can't afford it, and maybe a new payment plan can be set up. But as a result of those unpaid child support payments, he was jailed. And so that's kind of what we see today. We don't necessarily see debtors' prisons per se. You're not necessarily jailed because you owe somebody a certain amount of money, but instead it's kind of this roundabout way of getting people in jail by a judge ordering holding the defendant in contempt, and so because they're held in contempt, they're jailed. And so that was another thing that we saw. So in traffic court, what we saw, so I had gone, this was in district court in Baltimore City, and I went on several occasions, but usually what we would see is that there would be a bunch of people for a single traffic offense lumped together in one day in a couple hours, and so there were like 60 people there, and this was for a traffic ticket for not having a light rail pass, and so that was, I believe it was a $60 fine for that, and so there were about 60 people in the room who had this ticket. And the judge found all of them guilty, and assessed a $22 court fee on top of that ticket. So they had all come in to contest the ticket, and instead of finding any of them not guilty for not having the ticket because of some kind of personal circumstance or whatever, the judge also assessed a court fee on top of it. And there were at least 2 individuals there who were arguing that they didn't have the money to pay for the ticket, and they definitely didn't have the money to pay for the ticket plus the court fee. But in those circumstances, the judge said, I don't know what to tell you, I can't do anything about that, sorry. And so they left the courtroom, even though they had tried to contest the ticket in the first place, they left the courtroom having to pay both the ticket and the court fee on top of it. And so that creates this cycle for people without a lot of money, where they get stuck in this debt cycle where you go to court and you try to contest some issue and some ticket that you received and try and explain that you can't afford it, but then get these court fees added on top of it, and so the amount that you have to pay grows. And then in another area, and this was an issue before in Maryland. So in Maryland, driving on a suspended license was an arrestable offense. I believe it wasn't this past session, but the session before, that is no longer an arrestable offense, but it's a fine and you have to appear in court. But that issue still creates this endless cycle of owing money, going to court, getting court fees added onto it, owing more money. And there was one lady who testified in that session before, named Lisa Lowe, who had exactly this problem. She owed some money. She would go, and she might have missed. She wouldn't have been able to pay it. She didn't have the money to pay for the traffic ticket or whatever. And so, because of that, her driver's license would get suspended. And so this is another roundabout way of having people jailed. I mean, for her it was before this revision of that law happened, but where people are jailed because they can't afford to pay for a ticket. And so Lisa Lowe wasn't able to pay for her traffic ticket, had her driver's license suspended, but when you don't have a lot of money, you still have to go to work. And so you have to drive, even if your driver's license is suspended, and so then she would get arrested for having a driving on a suspended license. And even though it's no longer an arrestable offense, that endless cycle still continues, where you are too poor to afford to pay for a traffic ticket, yet you just get stuck in this debt cycle. And so there are a couple other things. This particularly affects homeless individuals, and there's one thing in particular that I wanted to flag about people who are homeless. And a lot of the time, at least with these show cause hearings, the homeless person doesn't have a permanent address, and so whenever there's a notice for a show cause hearing, they might not get it. And when they don't show up for their show cause hearing, the judge will issue an arrest warrant, and so then the person will be arrested for that. And so I guess in response to all of this, it's hard to quantify exactly how big of a problem it is. We know it's a problem just by going to court watch, but there isn't data collected on, for example, how often indigent defendants receive fees and fines without regard to their ability to pay, and how often those fees are waived. But from what we can tell, it is a fairly widespread problem, and we've talked to public defenders in Baltimore County, Harford County, Carroll County, and Talbot County. And so it's not just, it's a Maryland statewide issue. It's not just localized to Baltimore or anything like that. And I guess maybe one possible solution, although I don't know how effective it might be, to educate the bench in that they are allowed to waive fines and fees, because there have been at least a few public defenders who have said that when they appear before particular judges, they don't think, the judge doesn't think that they can waive a fee. And so they say, like, I have no choice over this, I have to give you this fee, I'm sorry. And maybe that issue might be helped with some education at the bench, but I'm not sure. That's all I got. Thank you.
Professor Colbert.
Why, thank you. My name's Doug Colbert. I teach at Maryland Francis King Carey School of Law. I came here in 1994, 23 years ago. When I came here, I went to visit the District Court of Maryland. What I saw was about 25 people handcuffed and shackled at the waist to each other come shuffling into the courtroom. They all appeared before the same judge. More than 90% of the people were African American. The judge told them they have a right to a lawyer, but it wouldn't take place at that hearing. The judge then said you have the right to say something in your behalf, but anything you say can and will be used against you. Only one person spoke, and that person was admonished for having asked for a lawyer at that hearing. That was 1994 in August. Our clinic, Access to Justice, represents only people at bail hearings. We work closely with the public defender. We represent public defender clients, and we represent people who are in jail charged with nonviolent crimes for one reason and one reason only. They cannot afford bail. And the bail would range from $100 usually to $1,000. It would be a $10,000 bond, which meant if you had $1,000, you could get out of jail. In Maryland, cases are automatically postponed for 30 days after the bail review hearing. That means that every single person who can't make bail remains in jail for 30 days. People lose jobs, they lose homes, they're away from family. I saw this situation, waited for my students to bring the issue for class, and then with the permission of Office of Public Defender and of the administrative judge, we began representing people. So I bring about 20 years of experience in the representation of individuals, but in 2006, our clinic and two pro bono lawyers from our state's largest law firm, Venable Batron Howard, brought a class action lawsuit, which subsequently became Richmond v. DeWolf. Paul was not then the public defender of Maryland, but when we filed it in '06, we argued that people have a constitutional and statutory right to a lawyer at bail. It took 7.5 years before our highest court agreed that poor people must be represented by a lawyer at the first appearance. I say all that merely as background. Obviously, if you want more information on that, I'd be more than happy to do it. But we have devoted enormous time to contribute to the reform of this system. I was in New York City. I was the equivalent of a public defender for 11 years with New York City Legal Aid Society. I then taught for 10 additional years in the clinic at Hofstra Law School, where we basically did the same work. In my opinion, there is no more critical stage in the prosecution of an accused than the initial bail appearance. Once you're able to get someone out of jail, you're able to provide a proper and full defense with the help of your client. You're also able to return your client where they have family, job, and where they have some substance abuse issues or other mental health issues. You're able to get them the supervision, you're able to get them a program. So when I came here, it was really a shock. I thought everyone did it like New York City. And I've written about the status of things nationally in several law review articles. I will say that Maryland is not alone. Most states, most localities use fines, fees, and bail for different purposes, for different in different ways. So it's not unusual to use money as a way of incarcerating people, of requiring conditions that low-income working people and poor people will not be able to meet easily, and many will not be able to meet at all. Ferguson, Missouri, their system focuses on fees and fines, mostly court fees, for revenue for their municipal court system. About 23% of their municipal court is provided by defendants who are paying their own fees and fines. Cleveland does it somewhat differently. They use very high fines, often resulting in incarceration. New Orleans public defender has relied on court fines in order to hire their own lawyers, which clearly presents a conflict of interest when you're representing someone and your salary depends upon it. Here in Maryland, it's kind of a mixed situation. And I want to tell you the good news. I'll tell you two things. The not so good news is that we don't have data to support how frequently fines and fees result in people staying in jail. I've called all the logical people. I called the chief judge of the district court and the administrative court. I've called the Baltimore jail and public safety. I've also called the Office of Public Defender. So no one really is keeping the data that you need to show just how extensive this is. But we do have, the good news is that the Maryland judiciary has agreed to pursue this information and to provide it to the commission. At least 30 days it will take them in order to create the program, probably a little longer than that, but I got that email back this morning. And I can give you that information if you'd like it. So the thing that happens, and I'm just going to give you an example. It was a New York Times front page story on August 2nd of 2015. The reporter's name is Shayla Dewan. She wrote about Danielle Hall, and this just gives you sort of an idea when we're talking about what happens to people. It looks like it's an uncomplicated situation. Ms. Hall was charged with a DWI. There was no complications. Nobody was injured. That was her first conviction. She got probation. It looked like, on paper, it looked like, a relatively easy situation. If she completed the probation, the conviction would be removed. So all looked good, but then you get the conditions that she had to fulfill. And this is where the fees and the fine and the bail all come together. The article is titled, "Probation May Sound Light, but Punishments Can Land Hard." And Judge Speakers was making reference to some of the consequences, perhaps unintended, perhaps not, of ordering money along to fulfill certain conditions. So she was placed on 18 months probation. Her fee for probation was $105, which included, it's a $50 monthly fee, and then there was an additional fee for a GPS device. So she had the $105 a month, but then she also had to attend DWI education classes, which was $70 a week. So that added another $280 monthly. So now she's having to pay $385 a month. The judge also gave her the condition of attending Alcoholics Anonymous class 3 days a week. And she has family, kids, she has 2 jobs that she's working. So of course, 3 days a week she's doing Alcoholics Anonymous. Originally, court costs were $252 and her bail was $2,000, meaning she had to give her bail bondsman $200 non-refundable fee. That's the way it began, but after a while, she moved, or she wanted to change places in public housing and she didn't notify the court. That became a violation of probation because she failed to notify the court. Then she didn't have sufficient verification that she was attending Alcoholics Anonymous. She brought back certain receipts, but not all of them. That led to the judge to another violation of probation, and the judge then set bail at $5,000 cash only. That's equivalent to a $50,000 bond. Remember now, this is her first misdemeanor conviction. She spent 34 days in jail. This was, and you can read all this in the New York Times article. She wound up, instead of getting no conviction, because she violated probation, she wound up with a conviction. Her license was suspended with the conviction for 6 months. She lost both jobs because she required a car in order to get to them. And of course she had so many issues in terms of family and things like that. So this is the way that fines, fees, and bail can compound a situation. When a judge sets $5,000 cash only, the people living in our city and through most of Maryland will be hard-pressed to make that kind of bail. So we do need more data. Hopefully that's going to be forthcoming. But the other point I want to make in the remaining time I have is to talk about another fee, another court-imposed fee. And that is the fee, 2 minutes. And that's, so you can ask me if you want more on this, but, and the fee here has to do with bail, has to do with money bail. Because once, and judges in our state, up until recently, up until the recent reform, they relied on money bail in about 2 out of 3 situations. It used to be that only 1 out of 3 people were released on recognizance here in Baltimore. So when you do money bail, that's when the bail bondsmen applaud that, because they are getting a 10% non-refundable fee for every bond that comes in. For people to get out of jail, people who don't own homes, they have to pay a 10% non-refundable fee. That's judicial imposed bond. So you're given, and that's where the recent reforms become so important to appreciate, because the judiciary recognized that so many people were staying in jail because they couldn't afford bail on nonviolent charges. Other people were getting out of jail who represented a danger to the community because they could afford the bail. So the judiciary makes these reforms. The bail bondsmen are really livid about that because it's cutting into their business. And so in the judiciary, in the legislature, where we spent 19 years trying to get reform, this was the first year, the very first year, because of a very powerful coalition that was formed, that was able to prevent the bail bondsmen from undoing, from reversing the Court of Appeals judicial reforms. And so there's a lot here for you folks to consider. But I think the most important thing is you have a judiciary that's willing to cooperate, provide information, and I think the New York Times story speaks to the judges who are using money in a way that will eventually have a huge cost on low-income working people as well as poor people.
Thank you. Thank you to all 3 panelists. I would like to open up the floor at this point to our committee members, and perhaps Pamela, I'll start with you if you have any specific questions for the panelists.
Well, initially I did. Nick may have clarified for me. I was a little bit confused about the relationship between the judge's ability to waive fees and the frequency with which I thought I understood that fees were transferred over to the central collections agent. I knew that.
Let me clarify that. There are in fact certain non-waivable fees. The court cost is a non-waivable fee. Actually, it is non-waivable. So we have no choice. We have no choice on that. The fees I was talking about routinely get waived, specifically the supervisory fees for parole probation, which again I think is bad policy. And my impression, remember that I'm king of my own courtroom and I'm king of nobody else's. And it might be king of that anymore because I'm your regular courtroom anymore. But every judge, and this is of course a problem that Nick did mention, the uniformity is a significant issue because I don't know what the judge even in the next door chambers is doing with their people. I know what I'm doing. I know anecdotally from discussions with friends of mine on the bench what they do. And my impression again is that supervisory fees are routinely waived because most everybody recognizes it's a dumb thing to do. And I think the reflection there is that in fact not a whole lot of money being collected. My suspicion is that means that many members are waiving those fees. And the response I got in check to some people seem to turn out in the defender's office. My impression is that this is not always routinely done. When it's not done, however, it creates a violation of probation and it creates a credit problem or a collection problem as some way or form. We also, there's an additional thing that I think is important. I generally do not waive restitution. I think restitution is a different category of thing from supervisory. Restitution is restorative justice. It is someone has harmed someone else and inflicted a cost on another person. The system, other than insurance, does not provide a mechanism for person number 2 to be made whole. And so I, generally speaking, would impose restitution when appropriate and unnecessary. So I view that as a different issue than the fees and fines, because I think there is a policy question there that I think does militate in favor of the person being harmed being made whole to the extent that it's possible.
So I can I add something?
Sure.
Is that okay? In terms of fees, whenever money is involved, I would say that the Constitution requires that a judge conducts an indigency hearing especially, particularly when the lawyer raises the issue of a client being too poor to pay a fee. And then once that happens, of course, judges like Judge Speakers, who were always very pleased to appear before, because in the same way like I prepared for this hearing by calling the judges who would give me their information, they too said the same thing. There's another group of judges that if I had made the same call, they would not have, been cooperative in giving any information. So that we have a lot of good judges, and then we have another group of judges that do not always, sometimes will set fees or monetary conditions that people can't afford. And I will also add that when it comes to, there was something that my colleague Mr. Steiner said earlier about that you won't be jailed because you owe money. And bail bondsman's power, just to give you a sense, is that they have the power to arrest you. If I don't like the way Ms. Hoffman is looking at me right now, I can take you to jail if I'm your bail bondsman, if you're a bonded defendant. I need no reason whatsoever. So when bondsmen are not getting paid their fee, their 10% fee, which often is on installment, I have the power to arrest, I have the power to enter your home, and this is, this is enormous power for citizens to have. The only other comment I want to make about restitution is, restitution serves a very important purpose, and Judge Speakers certainly identified it. But for people who lack money, for people who don't have that commodity, it would seem to me that judicial officers ought to be able to create another punishment that will give back something to the complaining witness. But money is the one commodity that separates the haves from the have-nots. People in this room, I'm going to make a big assumption here, but that people in this room either have or know people who have the money that would get each of us out of jail quickly. But 1/4 of the people in Baltimore are below the poverty line. The African American community suffers the most when money is involved. So even for restitution, I would say that you really got to inquire and find out what people are able to do. They're not showing disrespect, it's just a reality.
Thank you. Please, why don't you go back, please?
Thank you. I've heard statements from, I think, all three of you that may indicate an answer to this question, but if you're willing to state clearly your view as to whether or not these fees imposed are done primarily for punishment purposes, for, as you indicated, Mr. Colbert, to exert power and control over a defendant, or are they really for raising revenue for the state? Punishment, control, or revenue raising? Because you indicated...
I have absolutely no idea.
I was just going to say, I asked that question in light of your statement that that the money brought into the state really is de minimis. It has little impact in light of the huge impact that it has on individuals. So I think it's important for us to know if we think this is for revenue-raising purposes in light of it.
My suspicion is that it may originally have been for revenue-raising purposes, but that's just a guess. To me, it seems like a relic that just hangs on and creates problems, and this will sometimes happen. But beyond that, I just have no idea. I think court fees are frankly used for financing purposes. I don't think in Ferguson was like such an, I mean, based on what I know, and I'm not an expert on Ferguson, what they did, but the way in which they used the court system to generate revenue to fund the city government was extraordinary and outrageous. I don't think we do that. But I don't know what the origins of these policies are. I don't know what the initial intent was and the like. They just, just everybody goes along with it because that's the way it's always been, as far as I can tell.
I think most judges truly do their best to provide an outcome, a sentence, a punishment, a fee that fits the offense or fits the individual. Having said that, though, hearings go very quickly in the district court. It's very different where Judge Speakers is in the circuit court. That's where 8% of the cases wind up. So you have to really see where the volume is to see how quickly the bail hearings go. And it's extraordinarily rare for a judge to ask a defendant, how much do you earn? There's information there that would give the judge, say, look, I see you take home $250 a week and you have a family of 4. If I charged you 1 week, if I set bail in 1 week, do you think you're able to afford that? Because I need some assurance you're going to come back to court. That dialogue used to take place frequently when I practiced in New York. It hardly takes place now. So I think that I think there are some judges who, because they don't have the information, because they're not really interested in the information, or they move too quickly, the effect of that is to use money in a way that does punish. Although our Supreme Court says it's not punishment, it's just regulation of people in the administration of justice. I think when you lose your freedom for 1 day, much less 30 or 40 days, that's a pretty big punishment before you've had a trial.
I guess the only thing, I would add on whether or not it's used to fund the court. I guess what makes me think that that's not actually what's happening is the wide variety in which fines and fees are implemented on people. And if it was in fact because the court needed money, I would think that it would be more uniform across the board that judges would impose a certain amount of money on all the defendants to fund the court. And if it weren't so, I don't know why some judges would be like Judge Speakers and others would be on the other end of the spectrum.
So I have a number of questions, but let me focus on just
one.
One, yes.
First round.
Yes, so I have a number, but I'll focus on the one that kind of bothers me, I suppose, the most. And I guess it goes to what both Judge Speakers and what Mr. Steiner said as well. In some sense, I guess the question is, what's that alternative? So Judge Speakers pointed out that perhaps community service, and if we all have 24 hours a day, probably have different amounts of money in our bank accounts. But then the question is that community service true, given so we testify out that kind of has 2 jobs, 3 jobs already, how much free time do they have? As well as, Mr. Steiner's story that you brought up, right? Suspended license people do need to get to work, especially, perhaps in New York, your staff's slightly better because public education system is better than in Baltimore, perhaps out in the counties. And yet, obviously, people are driving in erratic fashion or driving wrong. There's got to be some sort of consequence. So I guess what really bothers me is what's the alternative? It's, what bothers me is the alternative is jail, right? And bother me because basically if you're poor, you just get to do it again and again and with no consequences. And I'm just wondering what is, perhaps suggestions, what's, from your experience, what actually works from the constitutional viewpoint, what actually would be fair?
When I first on the bench, and I was handling this huge number of probationers, I asked a friend of mine, actually the University of Baltimore Law School, Byron Warren, I've known since I was very young, and he as well. if you could do for me a literature search on what works in terms of probations. And I wanted to be, evidence informed. I wanted to know what worked. And there's a paucity of work, a real kind of sociological analysis of what works and what doesn't. And the consensus was there's only one system of probation that really works anywhere, and that is the Hope system in Hawaii, where the probation agent can put you in jail immediately for a day or so as punishment for any infraction. So actually, that's an ironic system that keeps people out of court but empowers the probation agent. Now, there's a lot to be said for pro and con. The pro is that the punishment immediately follows the infraction, and it's a mild punishment. So it's a mild punishment with certainty and immediately follows the action. That makes good sense. On the other hand, it raises the possibility of abuse, obviously, unless there's some supervision of the agents to make sure that they are not, in fact, power mad and abusive. And actually, there's many resources to analyze what you're doing. But to a large extent, you are flying blind and you're using your intuition and your common sense and the anecdotal evidence from your colleagues to figure out what works and what doesn't. And because you also can talk to public defenders and the state attorney to tell you what you do. You don't know. And you put your finger on a significant problem. If someone violates the law, we generally think the best thing to do is impose a sanction of some type, because otherwise, if there's no enforcement of the law at all, and most of the laws make some sense. So what exactly do you do? Now, the easy cases, and not easy in terms of the emotion and gravity of the case, the easy cases are terrible murders or horrible, assaults, because it's easy in the sense that that's likely to wind up in jail. And the other easy cases are someone who gets picked up for, 13 grams of marijuana, which is still a criminal offense. And it's easy because you do more probation before judgment, or you just have to do 10 hours of community service and come to go again. The hard cases are going to be cases that are intermediate in gravity, and we've had discussions as to how important these questions are. So if you watch television and you hear the guy's a drug dealer, what you're thinking of some guy driving around in a fancy car, flashy clothes, who's selling, tons of cocaine, it's on his trunk, and he carries a big gun. The reality is that most dealers are penny-in. They're small scale. There's been a couple of economic studies showing that drug dealers generally make less than minimum wage. It is not lucrative. It's a handful of people from this extremely lucrative. It's not lucrative for the average person. So you get someone who can't hold a job, he dropped out of high school when he was in 11th grade, so he's selling drugs in the corner, and you got in front of you, what do you do? And it's particularly a problem if it's a 20-year-old or a 25-year-old, I have a notion of what to do. If it's a 45-year-old, it's arrested for drug sales 15 times in the last 10 years, got 8 convictions. What do you do with that guy? And if anybody has a really good idea, please write it down and pass it to me. I'll pass it around to all my colleagues. But seriously, what do you do? Or the 50-year-old prostitute who has been financing her drug habit for years. As far as I can tell, none of my colleagues put prostitutes in jail. But do we have good diversion programs that are going to get their lives together? And by age 50, a prostitute is, they look like they're 80 years old. It is the most desperately difficult, hard thing to do. And so you wind up with these intermediate cases. These are really hard cases. And so, depending on the crimes, most judges will do something called a split sentence. They'll impose a figurative sentence, let's say 10 years. And they'll suspend all but a year of it, or a year and a half, or 5 years, whatever. They'll suspend most of it. And then they'll put them on probation. So they serve some time in jail. For nonviolent offenses in Maryland, I think you serve basically a third of your time roughly. So if I give you a 3-year sentence, you probably won't be out in a year to 18 months with parole. So you live under parole and under probation at that point. For a violent offense, it's 50%, and for capital crimes, it's more. But you look at that, and the real difficulty is what does one impose as a penalty? Yes, it obligated to everybody, poor people are likely more than everybody else. But we're really going through our armamentarium pretty quickly right there. So what is it one can do that protects the public, fundamental thing, and enforces the law, again, fundamental value of society, that minimizes the class distinctions, again, pretty fundamental, but it's still as effective, and that is really rare. And there aren't that many really good answers. Now, there's a program that the State Attorney's Office in Baltimore City started called the AIM program, AIM, Aim to Be More, which I'm the supervising judge for. And we take nonviolent first offenders, typically young, and we take them out of the normal system. It's probation for judgment, there's no conviction entered. We require them to do 150 hours of community service, a lot of community service. We require them to go to a job readiness program, typically the Center for Urban Families, more recently Captain Charities is the leader program. And then when that's done, we find them a job. And we've gotten commitments from a number of employers to hire people with this language for certain. So we replace them with Google Classrooms, with Sagamore. In fact, Sagamore's doing some really good work in terms of training with Amazon, McCormick, Hopkins. So some major employers are actually hiring these kids. And we have a very good record thus far. But remember, these are kids that you catch at age 20. Again, 45-year-old with a history of drug sales. There's no magic. I don't know what one does. One does the best one can. That's the problem.
Professor Colbert, do you have thoughts?
I do have thoughts. Thanks for asking. So, you asked an excellent question, Mr. Dolan, and I begin from the idea that we have to change the culture. For too long, we've relied on money as the difference maker between liberty and incarceration. We have risk assessment instruments that have been tested from the Arnold Foundation, for instance, 1.5 million cases, and they are able to identify the people who ought to be released, sometimes with supervision by pretrial services, sometimes other conditions, but they're not being held in jail because they don't have money. But the other part of it is that a risk assessment also identifies the people who are dangerous, the people who are going to go out and do more harm to the person who's a victim of domestic violence, for instance. And so risk assessment has been working more and more frequently in more and more states and localities, and it takes away more of the subjective quality that goes into a judge setting bail. But I also, I listened to my dear colleague Judge Speakers, and I've been practicing law for over 40 years, and I can tell you that just watching my students represent the individual who's got 15 or 20 convictions for CDS, or usually a woman, but not always, for prostitution. And I can tell you that when the student lawyers, and when lawyers generally take the time with the client and are able to be familiar with programs, residential programs in many cases, our clients have succeeded at a very high level. Our student lawyers will call up the program, will check in. For one of the rare times, and this is not a criticism of anything more than the volume of cases and the limited time, but the relationship between the lawyer and the client often can make the biggest difference. We don't have 100% success rate, but I can tell you that there are several instances of people who would only steal in order to support a drug habit. And if I was going in front of Judge Speakers, I would provide you with an alternative to jail pre-trial, not even after conviction.
Well, actually, I will say that, and none of you is a public defender, but I've told the public defender's office all the time, come into court with a plan.
Well, yeah, they have to. Every lawyer has to do
They're
that.
supposed to do that, but come in with a plan. I mean, this person obviously is a problem. Give me something to work with. And, that's an important point. Ladies and gentlemen, my wife is about to fly off to Europe, and I got to drive her to Dulles Airport. So with that, I had mentioned earlier that I'm going to have to leave. I do appreciate your attentiveness, and it's been a pleasure.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
And the last thing, when I say change the culture, money, follow what the Court of Appeals has done this year. It's taken a long time, but the Court of Appeals has now identified and told judges, thou shalt not put someone in jail where you know and are aware that they can't afford bail. You have to be thinking of other non-financial alternatives. Not every judge has gotten the message. Not every judge, because sometimes judges are doing something that I hope they desist from doing, which is they're denying bail altogether. But it's up to the lawyer, it's up to the prosecutor to come up with an alternative to keeping someone in jail for 30 or more days solely because they don't have the money. I look forward to the day, and I'll be quite honest with you, I look forward to the day where money is not being used, but we're making decisions based on objective criteria, where most people are going to be released from jail. Taxpayers are not going to be paying all this money every day. And if someone truly is a clear danger to another person, that person's not going to be able to get out of jail, at least until more information is forthcoming.
Mr. Simons?
Yeah, so it's a great question because it raises what what we're here for. Are we here for restorative justice, or are we here to punish the defendant? And I think, so even one day in jail can have incredible consequences. Someone who doesn't have that much money could lose their job if they don't show up to work, and the employer doesn't know where they work, and they could get fired for that. And so I just want to put that out there. I think with the money issue, I think using money is problematic, but if we do have to use money as a way to punish the defendant, I think it would make more sense to at the very least, consider the person's ability to pay. Because for the person who can't pay, then that punishment becomes an unbearable weight compared to the person who can. And then we're not giving people justice at that point. We're letting people with a lot of money off the hook, and we're letting people with very little money a burden that just can't be met. So I don't have a solution, but...
So, just for the record, the last question was asked by Greg Dolan, and next questioner is George Levin.
Thank you. I want to follow up on Professor Dolan's question because I think it's a good place for us to be. I'll address this to Mr. Steiner. Judge Spigas talked about using bracelets and other kinds of things to get people to show up for trial, and that's certainly something I guess we want to consider. But to take the two examples you used, the failure to pay child support and traffic issues, riding the light rail without paying for it. There was an article in the Sun the other day that said the light rail produces only 18% revenue for its costs, but we want people to ride the whole thing. So what's a judge to do in these cases? What's the appropriate sanction?
I think that there does need to be a sanction, or there's no point in having laws if there's no sanctions. I just think it needs to be proportionate, and the individual's ability to pay needs to be considered more so than it is right now, because of that unequal application of the law to people who can't afford the things that people with money can. With child support, it makes complete logical sense that you would want to arrest an individual who can afford child support to pay child support, but chooses not to. I think that makes sense. but when the person can't afford to pay for child support yet is obligated with these large payments, and you jail the person as a result, it has this kind of backwards logic to it, because the point is to get money for the child and in the best interest of the child, but if you jail the person, they'll probably end up losing their job and they don't have the money in the first place to pay for the child support, and so they lose their means of paying. And so I think that these consequences need to be thought through before one penalty doesn't fit all.
Can I follow up on that?
Well, as long as it's just a follow-up.
Yeah. What if the reason the person can't pay child support is because of irresponsible behavior on the part of the person?
I mean, I think those are all factors. I think money should be a factor. I think the other factors that go into why that person couldn't afford the child support payments need to be considered. And at this point, I don't think money is considered enough. I think it's easy to justify jailing somebody for not paying child support when, I mean, you say like, so for example, this guy who has an opioid addiction, who's now getting treatment for it, but if we just say he's just a drug addict, whatever, he can go to jail, that is a very incomplete picture of what's actually happening. And I think if our goal is, with our criminal justice system, is to rehabilitate people so they can be productive members of society, our current system does not make sense.
Yeah, I would only add that if we're talking about pretrial as opposed to after conviction, then we're looking at something other than a sanction. We might be looking for a condition. And the condition is that the person will return to court and that the person does not represent a danger of safety to another person or to the community generally. So I don't look at pretrial as anything other than if the state can present evidence that someone is a clear and convincing danger to another person's safety, then the judge ought to be denying bail to that individual. What we see on the other hand, I mean, when you look at Baltimore City Jail right now, we've got about 2,400 people in pretrial jail. 1,300 of them, more than half, are there because they're on warrants. They failed to come to court. They missed their court appearance. When you miss your court appearance, there are many judges who do what's called a preset bail. They will set a bail without waiting for the person to explain why you missed court. And with the preset bail, the practice in the city is for other judges to defer to the judge who preset bail, assuming that that judge had more information. That's often not the case. What's often the case is that the judge who ordered the warrant for the person's arrest, which is fine, adds a preset bail, usually because the judge is quite annoyed that somebody missed their court date. So I think, you know, what happens so frequently is, you know, that the law has to be followed. And the law says that the judge should be ordering the least onerous condition of release unless there's no condition that will ensure public safety or the person's appearance in court. So least onerous for one person might be money bail. Least onerous for another person might be reporting to pretrial or calling in at pretrial. It really depends on each individual. What happens, unfortunately, is that the system goes too quickly. The lawyer often doesn't even have time to speak to the client, much less verify information. So there are things that we can do to make this a much more humane system and to make it safer for the public.
We're going to be spending 2 panels this afternoon talking about the pretrial
part of this. I really want to keep this focused on the fines and fees aspect, which is essentially
You're right.
proposed. Genevieve Segura, you
Yes,
have a question?
my question has to do with the technology. Are there other technologies other than the ankle bracelet that was mentioned today that are currently being implemented in other jurisdictions that you're aware of? And if not, is there a way to make technology or systems more affordable? For example, is there a sliding scale according to one's income earning level?
I'm not aware of other technologies, but one of my colleagues was thinking that failures to appear are a large problem and why a lot of people get arrested. Meaning, like, they have a court date and they don't show up to court, and so the judge issues a warrant for their arrest because they didn't show up for court. And a lot of the time, that's because they don't know that they have a court date. And so, I mean, a very simple technological solution to this would have like an automated phone that calls out to defendants to remind them that they have a court date on Monday or something like that. That would, I would assume, to be very low cost and fairly effective.
The cell phones.
Right.
And risk assessment, again, when you think of technology, there is empirical data that's been tested, that it's not a final result. It does allow the prosecutor to add more information or the public defense lawyer to add more information, but it gives the decision maker at least a place where if you apply the empirical information, it tends to let the judge make a better informed decision.
Thank you. Doris Powell?
I just wanted to go back for a minute, and I know that you're on the criminal side, and Judge Sekas was, and I think that my concern is the district court side, where the fines and fees really occur. I think we've talked about some of the remedies of failure to appear and things that can be done there, and the bail issues. But I think that the issue that you talked about the person with the $60 light rail thing and the $22, I think we need to focus on finding remedies in those situations where there are mammoth fines. And maybe I don't know if you all know remedies of those things, but when many people, 60 people appear in court and are told you have a $60 fine and if you can't pay it, you now have a $22 fee, and it keeps perpetuating. And I think there are many fees that occur in district court, and there aren't those questions asked about, because there isn't the time given to the case. Are there any remedies you know of to cut down on those fees or court costs, or things to cut back on the fees in the district court system?
I would say the one suggestion I would make is that most people do not know their rights. And most people in traffic court and in the courts you're talking about are not represented by a lawyer or a public defender. So judges need to make people aware at the beginning of a session to say, for some of you, I'm going to impose a fine. For some of you, I'm going to impose court costs. The law requires that if you're an indigent person, if you're a poor person, I cannot impose those fines. So if you feel you have an argument here, I'm telling you that your right is you can ask for what's called an indigency hearing. And at that hearing, you'll be under oath. And you can say, I'm a veteran and I get $800 a month from my government, and that's all the money I have. And of course, when you're under oath, you're subject to perjury and things like that. But for most part, even though the example used was a really good one. If people had known that they have a right to at least ask for a hearing, then the people who are being charged the fees or the added costs are people who can afford them.
And I don't think I've ever heard that.
Mr. Steiner?
Yeah, I mean, I completely agree with that. I mean, I would also think, that if there's an attorney available, even then that attorney could be the one to advocate on behalf of. I mean, the traffic court watching that I did, there was no attorney. Everybody was unrepresented, and it's hard to say. I mean, from the public defenders that we spoke with, it seemed like their experience with the waiver of fines and fees was very different than what I saw in traffic court, for example, where there was no attorney. So it's very possible that the fact that there even is an attorney there gets the judge thinking about other possible options.
Jennifer Mathis.
So my question is a little bit related to Doris's, in that, I mean, I guess I've been wondering if there is one kind of, one type of change that we could recommend that would address all of these fairly different types of circumstances. It seems to me, I mean, you can talk about ankle bracelets and risk assessments, but in the context of a traffic ticket or child custody, or rather child support proceeding, that doesn't necessarily make sense. You know, there are, I assume, different statutes with different factors in terms of what the judge does when the judge exercises discretion. I don't know, maybe there's not. Is there sort of one, would it be a court rule change or a statutory change that, you know, we could recommend that would actually impact all of these different types of circumstances? And we've talked about 3. I don't know if there's, I assume there's other ones as well, or with a different context where there's fines and fees imposed.
My thought, I guess I don't know if there's one thing that can be done. I think if there is more consideration of the defendant's ability to pay generally across the board in bail, in traffic court, in child support, that would help. And I don't know if that would take the form of a court rule or a new legislative bill or
I would say begin with the idea of embracing the Court of Appeals revised rules, because they do much of what we're talking about here, and that was a real struggle and effort, and it overcame some very powerful forces that really wanted to maintain the current system, which focused on money as the commodity needed to regain liberty. So if you embrace the Court of Appeals, what you're really doing there is not letting money become the the bottom line for people. The other wish I have, and this is something I think respectfully, I think you can consider this, is eliminate the 30-day postponement, automatic postponement in district court from the time of the bail review to the next scheduled court hearing.
Again, let's stay with the
Oh,
fines
okay.
and fees side of this.
The fees and- okay.
We're gonna go to that part of the session, for which you're welcome to stay.
And in terms of ankle bracelets, in terms of the fees imposed there, that should be an item that the state covers the cost of that. The savings are quite significant, from paying $100 to $150 a day versus the $15 or $20 a day. So for indigent folks, that should be a cost that the state assumes. There is a big savings. That was fines and fees.
Tara Huffman.
Professor Colbert, you've spoken to what my question was, which is about an inquiry about a person's ability to pay before imposing any kind of financial sanction. I think, just based on what we've heard thus far, I think a policy that says there should be no imposition of any financial condition or burden pre-trial should be blanket social policy, because of you're innocent until proven guilty, and why should I bear any financial burden prior to you proving your case? Post-conviction, is it written in court rule, state law, or even constitutional law that there shall be, must be, an inquiry into a person's ability to pay before imposing a fine in particular, or even a fee? Like, is that something that we're saying the law would support that and that's good practice, or is there like some language somewhere in either constitutional case law, a state statute, or even a court rule, besides the court rule that's going into effect on July 1, that says that that inquiry must happen, shall happen before imposition of any financial sanction?
Well, yes, and I think equal protection of laws and due process protection of liberty and property would apply to a sentencing situation. When you say post-conviction, I'm assuming that you're talking about the sentence. And, and again, it's going to be up to the lawyer, always, in the same way like the first part of your comment, the lawyer whose client is receiving a fee or a fine that's excessive, well, that lawyer has got to make a very good record and then has to be able to go to the next level of appeal. If the lawyer doesn't follow through on that, then of course the judge's ruling is going to stand. But for the time of sentencing, any time a person is given a condition which is going to either violate the 8th Amendment prohibition on excessive fines or punishment, I mean, you've got the 8th Amendment on excessiveness, you've got the 14th Amendment. So these constitutional arguments, I feel, are very much in play at sentencing as well as at the pretrial level. And I would like to see more litigation, particularly in the glaring examples where judges are doing something. And again, I don't mean to condemn all judges. It's really important that that's clear. But there is a growing number, and that's disturbing, who seem to be less aware of people's inability. Now, maybe it's just an educational problem, but I think Chief Judge Marcy did a very good job of explaining the new changes, and yet we're still seeing too many judges who are using money in ways that's not appropriate. So the answer to your question is yes, there is a constitutional right and argument that ought to be pursued.
And just to clarify, but that is a defense, it's not affirmative. Like is there an affirmative requirement on the judicial officer to make that inquiry? I get that the defense counsel can raise it, wait a minute, that's too excessive for my client. Is there an affirmative responsibility?
It's in the statute. I mean, it's in the rule that says that judicial officers must consider a defendant's financial circumstances. And one of the reforms that our clinic did years ago was to actually get that information when you first appear before a commissioner. So now the commissioner is going to ask each person, are you working? How much do you earn? What's your family? What are your expenses? It's right in the case file. So the information's there for judges to look at. They're supposed to be considering financial circumstances.
I have one question. There was, I believe that Judge Stikas mentioned this, and both of you mentioned this as well, which is the difficulty with data and understanding the scope of this issue and the extent to which people are in fact incarcerated today because of their failure, let alone inability, failure to pay fines and fees. I think Professor Colbert, you mentioned that there's some understanding somehow that some of that data is going to be provided. Can you clarify that? What sort of data has been requested, if any, with respect to incarceration of people for failure to pay fines and fees? And what are the challenges for the court system to provide that kind of information?
Well, the challenge question, look, I'm the last person to ask about technology, but the program can certainly be created that will capture the information that you're seeking. And I say that not because I'm an authority, but because the response I got from an email that I received this morning, they identified 4 different areas, and they encouraged the commission or myself to add any other information that they're seeking. So if you want to, I can wait in responding, or I can say I presented this and the commission was quite interested. I can send over the email that I got this morning. But what they suggested was that they were going to find out how many people were sentenced to jail in lieu of being able to pay the fine. I think that there are other categories, for instance, probation is a likely place where people will face a violation of probation for either not making restitution, not paying off other costs. I think that's what happened to the New York Times individual. She just was so overwhelmed with more debt. So I think what we can do is to take advantage of a very willing judiciary. They are very interested in trying to capture the information, and I think that should be very helpful to your work.
Mr. Steiner, any?
Yeah, I mean, I would agree with all of that, and I would think that the judiciary would be open to that kind of data collecting, only because it would help with judicial efficiency and making the process fairer for everyone.
So we're now at 20 minutes of the hour. I would like to thank the panelists for their contribution, for their time, for their thoughtfulness. I'd like to thank the community members for their questions. I think this will bring this panel to a close. We will take about 5 minutes for 10 minutes for a break, and then we will convene the next panel, which turns to the issue of bail reform. Thank you very much. Everybody, I hope everyone had a chance for an appropriate break. We just spent in the first panel a rich discussion around the issue of fines and fees. We're going to shift gears now and move to the pre-trial, essentially, phase of things as opposed to the post-trial phase of things. We have 4 panelists, and I'm grateful to all of you for coming. Mr. Paul Wolf, Public Defender, Maryland Public Defender's Office. Zina McCart, Clinical Fellow at University of Maryland School of Law. University of Baltimore School of Law, my apologies. And my colleague Greg Nolan just explained the difference to me a moment ago, and that's what I get for mindlessly reading up the page. Michael American, Assistant Sheriff, St. Mary's County Sheriff's Office. Thank you. And Jackie Robarge, the Executive Director for Power Inside. Yes? Well, thank you all for coming. I'm just going to go in the order that the names are listed on the sheet, which appears to be alphabetical. So with that, Mr. DeWolf, if you don't mind kicking things off. And just to be clear, each of you will have 12 minutes. I'm trying my best to enforce the 12-minute limit, and there will be an opportunity for questions that follow.
Yes. Here, so you just hit All right, I have a few slides, so if you don't mind, I'll speak from here. But I'm going to be referencing a report that was put together by the Office of the Public Defender, and it's dated November of 2016. It's called The High Cost of Bail, How Maryland's Reliance on Money Bail Jails the Poor and Costs the Community Millions. I didn't bring copies for everybody, but it can be accessed on the website of the Public Defender's Office, www.opd.state.md.us. Just Google Maryland Public Defender's Office, and you can get to the website.
Will you please just restate that for the folks on the webcast?
Yes, opd.state.md.us.
Thank you.
Okay, and the methodology is explained in the report, but basically what the researchers that were working with the office did was they analyzed 700,000 cases from the district court criminal case file. And this is a time period of 5 years between 2011 and 2015 in 18 jurisdictions. So any of the data that is discussed here will necessarily be underreported because we could only cover 18 of the 24 jurisdictions. The reason for that is the other jurisdictions have since switched to a different database, the MDEC database. So we were only able to access 18 of the 24 jurisdictions. Anyway, the sample size was 700,000 cases. So to begin with, we wanted to look at who is affected most by the wealth-based system. The report kind of tracks, I think for the first time, the wealth-based system and where the money is coming from and going to with respect to premiums, corporate premiums, and debt that is charged on bail amounts. So the first slide shows that there were no fewer than 46,000 defendants were detained on bail for more than 5 days. 5 days is significant because anybody that's been in jail for more than 3 days, all kinds of consequences can occur, loss of jobs, loss of children, and things of that nature. Certainly the loss of liberty for 5 days is significant. Of those cases, 17,434 were held on detained on bail less than $5,000. And what that means in dollars is that these individuals, 17,000 individuals, were unable to pay a bondsman $500. They didn't have $500 to bail themselves out. The bails go up between $5,000 and $50,000. There were over 21,000, and then it drops off as you get to the higher bails. The other significance of the $5,000 amount is that I think we can presume that that's a relatively low bail. Certainly for Baltimore City, it's a low bail. So we can presume that the judges put on a very relatively small bail, thinking that the person perhaps could make that amount. And as you can see, there are at least 17,000 people that could not even make the $500. The next significant, so that's the data that I just talked about. There were over $20,000 bails with bails of $5,000 to $50,000, meaning if a person could come up with $5,000 or $500, they would have, between $500 and $5,000, they would have been released. This is where the tracking of the wealth-based system comes into effect. During this 5-year period, there was the total in these 18 jurisdictions, $256 million in corporate premiums that were charged by the setting of bail. $256 million. Now, that doesn't mean that people posted $256 million, but that's what they would have needed to post in order to get released from these, and again, these are presumptively innocent people that are required to post this amount of money. By jurisdiction, it's significant. The highest amount, Baltimore City, well over $100,000 in corporate premiums during that period of time. The next nearest is Baltimore County, and it goes significantly down from there. So the significance of this is that the transfer of wealth from communities really affect the poorest communities in Maryland significantly. As you can see, some of the larger counties and more wealthy counties, the bail amounts are significantly lower. There were a significant amount of money that was paid by individuals that were never found to be guilty of anything. So, for example, more than $75 million was paid in bail premiums by individuals who were never convicted of a single offense. And then, again, that's money that's transferred from this community to the industry. And I think this slide really does tell a significant part of the story, and that is that the corporate bonds were really extracted from some of the poorest communities. Of the top 15 communities, all of them were in Baltimore City or in Baltimore County. And for example, the zip code of 21215, Park Heights in Baltimore, over $11 million in premiums were charged during that period of time. And in Sandtown, Winchester, again, more than $11 million. Now, these two communities represent the communities in which 26% of the communities is below the poverty line in Park Heights, and 35% are below the poverty line in Sandtown, Winchester. And it really does go on and on. In southwest Baltimore, 42% of the individuals in that area live below the poverty line, and over $8 million was charged in premium. One of the things that we really that we were able to pick up, and this is, I think, most significant to this meeting, is that money bail disproportionately impacts black defendants. The median bail amount imposed by district court commissioners were 45% higher for black defendants than for the white counterparts at the initial appearance before the district court. And it's even worse before the district court. Bail amounts were 51% higher for African Americans than they were for the white counterparts before the district court. Many factors can affect the setting of bail, including the defendant's criminal history of failure to appear, employment status, or other factors. Therefore, we can't really say what the motivation was, but there's no question about the racial disparity in the amounts imposed. This necessarily leads to racial disparity in the amounts, in the bail amounts of premiums charged to black defendants. During this period of time, this 5-year period, under this study, black defendants were charged more than $181 million in premiums by the bail bond industry, more than twice the premiums charged to the defendants of all other races combined, even though approximately only 30% of Maryland population identifies as black. One of the, I guess the untold story of all of this is the debt, the ensuing debt that is imposed upon these poor communities. Obviously, there were 17,000 people that couldn't come up with $500 to get in order to get out of jail. But those that did post money to get out, they were left with enormous amounts of debt. And you can see from the neighborhoods, the zip code neighborhoods, $22 million in debt from Sandstown, Winchester, and Park Heights transferred. Now, what happens? What happens with that debt when the people can't post it? They go into the civil debt collection system. Some debts are sold to law firms that collect debts. Judgments are gained in person. We talked earlier about fines and fees and how judgments against individuals are sent to central collection, and that follows them. It follows their credit rating, and it follows them if they get a tax return or anything. It's all collected. But it's just an enormous amount of wealth and debt that is imposed on the poorest communities and transferred to an industry for profit. So there is a better way. And I've got about 2 minutes. What I'd like to talk about is the enormous efforts that these folks and the coalition members that you've heard about earlier that are working on bail reform. And the court rule, which I think we'll hear more about from Zena, is a step towards reforming this wealth-based system. Doug Colbert talked about moving towards an evidence-based system, which uses data and risk assessments, and that informs judges' decisions as opposed to putting money on individuals. And then there's so much more that we can do in terms of supervision in the community and to move away from the wealth-based system. Those jurisdictions that have moved away from money, away from the wealth-based system, into a system of evidence-based practices have done so without damage to the failure to appear rate or the reoffending rate. DC releases 90 to 95% of the individuals that are arrested, releases them without money bail, and over 90% return back to the court. And Mike American, I think, is an example of Captain American, I'm sorry. Major. Every time I want to bail with him, he's gotten another. Anyway, it is an example of how we can move away from wealth-based system to an evidence-based system. So I'd like to tell you something.
Thank you very much. Next is Zena McCarr.
Thank you. Good afternoon, everyone. I also have a PowerPoint, so let me pull this up. So I am the co-director of the Pretrial Justice Clinic at the University of Baltimore School of Law. Our clinic started fall 2016, so we're kind of the new kids on the block. We do a lot of similar work that Doug does at University of Maryland, but we mostly focus on habeas corpus petitions, and we generally challenge, the students generally challenge felony cases, more serious offenses. But lately, we saw, this past semester particularly, we saw a trend of having more misdemeanor clients that were held without bail. So today, I'm going to talk to you about preventative detention. We're talking about the rule change and the trends that we've seen thus far, so I'll briefly touch upon money bail, but Paul already did such an excellent job of touching on the collateral consequences of money bail. I'm going to identify problems that were pre-existing in the system, specifically with regard to preventative detention, but those problems have been highlighted and exacerbated by the rule change. And then I'm going to provide you all with some recommendations. So first, before we get into the state issues, I just want to frame this in terms of a national perspective and why we need pretrial reform, particularly because it's been contributing to mass incarceration. I don't know if anyone is, I'm sure you all are familiar with the term mass incarceration, but lately there's been a trend of law scholars trying to redefine what mass incarceration means. It's not just about the convictions and the long sentences. It's more so about looking at the system as a whole. So I'd urge you all to think about mass incarceration in terms of pretrial detention and the consequences that begin at the front end of the system, more of a fluid concept, if you will. So if you see this tealish section, it's about 60% of the entire pie chart. This pie chart represents about 2.3 million people. It's a static snapshot of the U.S. incarceration. Well, who is incarcerated today? I think this was produced in around some date in 2016 by the Prison Policy Institute. So this blue piece right here is about 60% of the pie chart. It shows the number of people who have been convicted of a crime. The second biggest piece, it's about 20% of the pie chart. In comparison, it's maybe minimal, but what is not reflected in this snapshot, and that 20% of pretrial incarceration population, those who have not been convicted of a crime. What you're not seeing in the snapshot, though, is the churn rate that is going through. So with the prison population, that's about 1,300,000 people. Those individuals stay about the same. You might be incarcerated, you might be incarcerated, you might be incarcerated. Those are the same people. But with the jail system, you have a churn rate, and that's a different, unique individual each time. You have about 11.4 million people entering jails each year, and that number is still increasing. So 11.4 million people are being arrested and touching the jail system in some way, whether it be for a day, 2 days, a month, or a year. And they're all waiting pretrial incarceration. Only 5% of those people are actually being admitted into prisons. That means that only 5% of those people that go through the jail system are actually being convicted of a crime. So let's switch it over to the state problems that we're seeing. You all have heard a lot about the collateral consequences of money bail, and so I'm not going to really touch upon that, but I would definitely urge you all to take a look at Paul's excellent study called The High Cost of Bail. It shows it has a lot of narrative and it demonstrates the collateral consequences. I also recommend that you look at the Arnold Foundation's report. I believe that's called The Hidden Cost of Pretrial Detention. That report came out in 2013, and it touches upon recidivism issues with pretrial detention, the destabilizing impact, particularly on communities of color, poor communities. It's particularly enlightening study, and I definitely recommend you all review that. So you're probably asking what happened with the rule change. So the rule was signed into effect by the Court of Appeals in February of this year. It doesn't take effect until July 1st of this year. However, bail reform was sparked much sooner than that. It was sparked around October, 4 months earlier of 2016. And that was by way of the Attorney General issuing an advisory letter on the unconstitutionality of money bail. He advised that the use of unaffordable money bail would likely be unconstitutional and violate equal protection. So, in light of that, 4 months later, the Court of Appeals signed into effect a rule change. And what it does is essentially two things. It prevents courts from detaining people, someone based on their inability to pay. However, it does not eliminate money bail completely. Now, we are seeing positive trends in that area, as Paul mentioned, but it's still an issue that needs attention. What I'm going to focus on is the second point, however. The rule change essentially is prohibiting judges from setting monetary release conditions for the purposes of affecting public safety, particularly dangerousness, and that's where preventative detention comes in. And there we are seeing negative trends. So this small amount of data from this very small 4-month subset shows that there's been a 7% decrease in the use of money bail since the Attorney General's advisory letter. This is a huge change. It's a move in the right direction, and we're very glad to see it. But we are also seeing a 5% increase in the use of preventative detention. And here's the reason. This is just a snapshot of the preventative detention data. Now, on the left you have Maryland, and on the right you have Baltimore City, and you can see July, August, September, in both charts they're about the same. And then you see this unprecedented spike in the use of preventative detention going up in about October and November, reaching to unprecedented highs, and that we're expecting that trend to continue, especially since the rule change doesn't take formal effect until July 1st. So I urge that this committee take action to look at this issue, because it's probably only going to get worse. I know that you probably are all asking yourselves, well, if somebody's being detained prior to trial, maybe they are dangerous. But I would suggest that that's probably not the case. So before I talk a little bit more about preventative detention, I just want to frame this visually for you as to what's going on with the rule change. So the Court of Appeals was trying to get this ideal. This isn't really to proportion, it's just to show you what the foundation of the system is. The foundation of the bail system must rely on release on recognizance. That's the presumption. Then, if release on recognizance is inappropriate, courts can then turn to conditional release, but not necessarily monetary conditional release. However, well, I'll get to that in a moment, but the last resort is held without bail. That's supposed to be a carefully limited exception. Last resort, very, very, very few people are supposed to be held without bail. In reality, pre the Attorney General letter, this was what was happening in Maryland. You had conditional release as the foundation. Money bail was being used almost exclusively. If not, you had held without bail. And then very rarely were individuals actually released on recognizance. Then come the rule change, and that conditional release, because courts only relied on money bail, it collapsed. It's kind of gone now. So what happened with what was left? All of those people who were given conditional release, such as $10,000 bails, misdemeanor cases, low-level offenses, they are being held without bail because courts need to understand, and pretrial services needs to understand, what other options of pretrial release, what other types of conditional release is available. Because this is not to proportion, but you're going to start to see a significant amount of cases starting to collapse into the held without bail, which comes to that issue of unnecessary incarceration, mass incarceration, that you're really concerned with. And I heard one of the members of the committee ask a question earlier about punishment. This is effectively becoming a proxy for punishment. Preventative detention is becoming a proxy for punishment. There's a study that was recently done in Florida that indicated that the amount of if someone's custody status prior to trial would indicate whether or not what their case disposition was, and particularly for misdemeanor cases, you were 4 times more likely to plead guilty if you were incarcerated prior to trial, showing that there is a coercive effect through the use of through the use of preventative detention, particularly even in the case of money bail where someone can't afford to pay. And I see I have 4 minutes left, but let me kind of just end on a small anecdote for all of you before I get into my recommendations. So there is good case law out there on how preventative detention should be handled, but simply because a rule exists doesn't mean that it's actually being followed. Judges are essentially paying lip service to this rule, and it's being misapplied holistically in district court, in circuit court, and even other courts around. So last week I was in court and my students were arguing in bail modifications, a particularly heinous case. My student was arguing that United States v. Salerno, Supreme Court case, later adopted in 2005 by Wheeler, by the Court of Appeals, same standards, was arguing that the court must hold, by clear and convincing evidence, a heightened standard that someone should be detained, that the state has the burden to detain, or the burden of presumption in order to require somebody to be detained prior to trial. The state's attorney objected and said that no, Your Honor, you have to take the evidence in light most favorable to the state at the pretrial stage. You have to take that in most favorable to the state. And surprisingly, the judge said, I agree. Our student attorney bravely objected to the judge and started reading this quote. It's a famous quote from U.S. v. Salerno. She started saying, in our society, liberty is the norm. And the judge cut her off and said, thank you, counsel. I already know what Salerno stands for. Please continue with the rest of your argument. Needless to say, the court held my client without bail, and I'd like to add just the fact that the only evidence that the state had in the case was a statement of probable cause that described a heinous crime and later said, through an anonymous tip, we believe that your client committed this crime. Most courts and federal courts would not find probable cause even, so certainly you wouldn't be able to find clear and convincing evidence. So he's currently been detained for 220 days because of the misapplication of Salerno, the misapplication of state law. So this leads me into my recommendations, and one of my biggest recommendations, besides the first, is education. There needs to be additional educational measures for prosecutors, for the courts, even defense attorneys, I'd say, and I failed to put that up there, but I'd say that even defense attorneys should have this type of education on the proper uses of preventative detention. I would even add data to the list. Data would be extremely helpful in this case, given how little information we have since the rule change took effect. We only have 4 months of data. More data on this would be particularly helpful, particularly around the coercive effects of pretrial incarceration and how it leads into plea deals. And I'd also just suggest that probably one of the biggest reasons for this misapplication and preventative detention statutes is actually one thing that Judge Stikas mentioned. Judge Stikas mentioned that there's kind of 3 systems of criminal justice we have. We have a federal justice system, we have a state justice system, and we have a juvenile justice system. Salerno comes from the federal justice system, and as you all well know, federal cases are not often violent. They are white-collar crimes, and they very rarely involve that kind of violence and that kind of dangerousness that we are so concerned with. And the federal government has the resources and the luxury to actually hold 2-week-long bail hearings in order to determine whether or not to detain somebody. State courts, don't have those resources. They go through these bail hearings way too fast, and it fails, they lack accuracy, and it results in unnecessary incarceration. But also, state courts handle 85% of the violence that occurs in the United States. They handle all those violent crimes, and it is extremely hard for those state courts to actually implement proper measures in order to keep the community safe, but also make sure that held without bail is a carefully limited exception. So, I know that this was a lot of information, so I'm definitely happy to answer questions and the nuances about preventative detention, but I will just leave you with Paul DeWolf was mentioning a few resources we have on our clinic. If you Google pretrial justice clinic, on our clinic page we have a full resource page of all of these different studies that I mentioned, additional studies in media, even the data that bail bondsmen use, and I'm sure that they will be talking about that later today. And we have data, all the data that you can ever imagine. So please visit the website, and thank you all for your time. I hope you take into consideration our recommendations. I can just leave that up there if no one else has any.
That's fine. Thanks. Thank you so much. Next up is Major Michael American.
Mr. Chair, thank you for the invitation today to this committee and being able to give a briefing, and more importantly, allow local jails to have a voice in this. We've heard a lot about defendants and offenders and the cost and the bottom lines, but there's also a cost and bottom line to those that manage the jails. And it's very important for people to understand as well, because the folks in there do walk the toughest beat. When you're dealing with pretrial people in jails, you are mixing them with convicted offenders too. So it is very important to understand when we do put folks in jail that we put the right people in jail. Before being appointed to assistant sheriff by my boss, after accolades from Mr. DeWolf here, got me my promotion, maybe we can have a beer one day.
Identified him as the sheriff, and the sheriff came up to me and said, "No, I'm the sheriff."
He said I was the best sheriff in America.
That's right.
But I spent 11 years as the warden of his jail. And in 2014, as president of the Maryland Correctional Administrators Association, I was on the roller coaster with the pretrial reform and the Governor's Commission. So that's how I come into play with this. And I didn't bring pie charts and everything else, thankfully, but I think I get an A+ when I read some of my data from the 2 folks here that have given a presentation, and for the public in general, I'll give you my dissertation. America accounts for only 5% of the world's population, but yet we are responsible for 25% of the world's incarcerated population. And it costs us $80 billion annually. Data also tells us nationwide pretrial inmate populations of 60% cost us another $9 billion a year. We buy a lot of groceries with that from those people. The Bureau of Justice Statistics reported in 2006, 40 of 50 states recorded their prison populations at 90% or better, with 23 citing overcapacity. In 2005, the state of Maryland reported the St. Mary's County Detention Center as the most overcrowded jail in the state. The Bureau of Justice Statistics also reported in 2014, 15.7 of the 1.3 million state prisoners' most serious offense was a drug charge. In 2015, they reported 3.7 million persons on probation. 25%'s most serious offense was a drug charge. And of the 870,000 people on parole, 31% most serious offense was a drug charge. And we're in the height of an opioid epidemic in Maryland, where 5 people a day are dying, is what I was reported from the governor's office last week. Nothing's changed, ladies and gentlemen. America has the largest appetite for incarcerating our problems, and over the years we've managed to fill our jails and prisons to a point for which we can no longer afford. In 2012, St. Mary's County had state authorization, after 7 years of hard work, to proceed with a jail expansion and renovation, which included a 50% cost match for the $32 million project. The sticker price was not appealing to our local leadership. The project was abandoned, and we continue to this day on the fourth version for approval. Faced with overcrowding and the lack of adequate space needs, our jails and prisons continue to focus on the best practices for inmate population management, and St. Mary's County is no different. 2014, I had the honor to serve on the Maryland Governor's Commission for Pretrial Bail Reform. There was a lot of energy from the commission members, as well as public interest groups towards this effort, both for and against the issue. But more significantly was the inability of our General Assembly to come to any change toward the bail reform issue at the end of the day. Once again, I was not surprised by the results of our political leadership, but this time the education I received was not going to be wasted. I directed my personnel to proceed on the development of pretrial services program. Understanding the cash bail issue will be bigger than us. We developed a process that would be introduced after the initial appearance before a district court commissioner, and only after it was determined the offender could not afford the conditions of cash bail. The offender is interviewed, and all critical information necessary to ensure public safety and court appearance is verified and presented to the sitting judge in order to make an informed decision. This information is also provided to the state's attorney, defense counsel prior to court, ensuring all stakeholders are at the table determining the conditions for release or continued detention. Understand, our pretrial services program does not eliminate cash bail in our county, but provides our judiciary with a menu of alternatives to pretrial incarceration. Please remember that pretrial services comes after bail is no longer affordable or becomes a different issue. As a 34-year veteran of law enforcement, I question the bail system we have had in place since the establishment of our Constitution, as nobody is watching these individuals once released on cash bail, not the bail bondsman or the district court commissioner. Through utilization of a modern and properly facilitated pretrial services program, officers are assigned a case manager and must follow strict rules and guidelines. GPS monitoring, weekly drug testing, or otherwise face incarceration for non-compliance until the respective court date. Some of the programs mandated or available to those offenders being monitored include mental health treatment, substance abuse treatment, veterans assistance, domestic violence treatment, anger management treatment, affordable health care enrollment, affordable housing and homeless shelter placement, social security enrollment, employment skills, education, literacy, community mediation, and social service referrals, to name a few. These functions never occur under the watchful eye of a bail bondsman or district court commissioner, whose only option seems to be incarceration. Pretrial services is not a get-out-of-jail-free card where everyone gets a trophy initiative. In the past year, our program, only 20% of all intakes were eligible to participate in the program. Of that 20%, 77% remained compliant. The non-compliant accounted for 9% receiving new charges, 1% for failure to appear, and 13% administratively removed for violating conditions. More importantly, those completing the program successfully realized a remarkable 70% no jail sentence upon adjudication. Our program also identified 69% of all participants were referred for substance abuse treatment. Hear the common theme? And 10% were enrolled in affordable care. Another noteworthy statistic was our average daily population. In 2015, the year prior to the program implementation, we realized a sentenced population of 57% and pretrial detention of 43%. In 2016, our sentenced population was 48%, pretrial detention 33%, and pretrial community 19%. Although we realized an increase in population over the past year by adding the community supervision component, our overall incarcerated population decreased by the same amount of the increase. Essentially, the right people are now in jail. Certainly there is a cost for doing business, but it's significantly cheaper to monitor on the outside of the fence versus inside. You all have heard that spread throughout every theme, I'm sure. Our FY17 projected inmate cost per day on 78,855 prisoners' days is $149.05. Pretrial costs on 16,790 offender days is $29.78. It's a difference of $130 a day, ladies and gentlemen. So there is a significant shift in cost, but nonetheless, please remember it takes staff members to facilitate the program. We were fortunate and only needed to hire one additional officer, shifting the remaining duties within the facility to make the project work. So I was lucky, although it was a perfect storm for us. In conclusion, as we struggle to decide whether our bail system is outdated or broken, we fail to build bigger prisons or jails, we continue to incarcerate minor offenders, we inadequately fund substance abuse and mental health treatment programs, understand each day, month, year, our communities continue to absorb these folks back into society, as 95% of all offenders released from jail return to a neighborhood near you. That's our program in St. Mary's. It took me a year to get it up and running. I had great staff. A lot of my colleagues have asked me, we'd love to see it in Maryland. I'm sure there'll be a dialogue here. That is the reason and purpose I'm here today, to tell you that it can be done if you want to do pretrial supervision. It's just up to your communities to understand what's important and what isn't. And I thank you all for giving me the time.
Thank you, Major. Our next panelist is Jacqueline Robarge with Power Inside.
Hi. Thanks for having me. I am Jacqueline Robarge for Power Inside. Power Inside is a 17-year-old program that focuses specifically on women cycling through pretrial detention. So we've served over 4,000 women in the last 17 years, all who have been arrested and spent at least one day in jail. So they're cycling very rapidly, and some have been in pretrial for as long as a year or more. So a lot of the information that I'll provide is based on our anecdotal work with the women in pretrial, but we've also done studies with Johns Hopkins University and other researchers to kind of build out some of the information that I'll share. So as a provider attending to the needs of women in pretrial detention, both inside the detention center and in the community, we've seen numerous women held on $100 bail, $200, $500 bail that they're completely unable to afford. That is because the bulk of the women that are cycling through pretrial detention are there on drug and property crimes and are very, very poor. And so any period of detention, they are destabilized in a lot of ways, even already being vulnerable, meaning they have health care in the community, they're seeking services with programs such as ours, or they're staying with family, and any time in jail is a time away where they're not paying rent, they're not getting the health care they need. And so, I kind of want to say that, I've heard earlier that jail is kind of a compassionate approach to providing services to highly vulnerable people. And arrest and detention, that experience is much more harmful than it is good. So I just wanted to say that. As we know, and we've heard earlier, money bail does really nothing for poor people. They are unable to get out of jail. They're detained there on low-level offenses. But with our clients, most of whom are survivors of domestic violence and sexual assault, that's about 90% of our caseload, they are detained in jail while their abusers are able to pay money to get out because they can afford bail. And so I'm not trying to propose that we go the route of preemptive detention, but I do want to say that the current system does nothing to increase public safety or protect survivors of violence. Because were that the case, our clients would have some protection and the system would work for them because they are mostly survivors of violence. So why talk specifically about women? Well, women, as I said, are disproportionately arrested and detained on low-level drug offenses, are disproportionately black, and are disproportionately homeless and poor. And so our program, because it focuses on the specific needs of those women and their individual circumstances, really could be a weather vane for how we need to go about pretrial services, pretrial supervision, and actually preventing their entrance into the pretrial system altogether. So we did a survey of women in the Baltimore City Detention Center with Johns Hopkins University, and it was published in the Journal of Urban Health, and we found that women detained in the detention center are disproportionately black, suffer high rates of addiction and mental illness, that was about 60%. Were unstably housed, almost half of them had no stable housing beyond 30 days. And 1 in 4 had no idea where they would go after they got out of jail at all. And poor women, lesbian and bisexual women, and women with histories of prostitution had even higher rates of homelessness, nearly 4 times that of the already homeless and poorly housed women. So I'm going to give you a couple case histories to kind of further complicate, this discussion. And as you listen, consider the multiple systems that are intersecting these women's lives, because pretrial reform cannot only be about bail reform. While that is essential and a necessary first step, we also need to look at the various ways people end up in this system. So I'll tell you a story about Kim. Kim has been involved in our program by the time we were working with her for about 10 years, since she was 17 years old. She had already been homeless for several years when we met her, and she slept in abandoned houses and engaged in prostitution and committed petty theft, all in service to her basic survival. Once as an adult, she started accumulating misdemeanor charges related to her circumstances. On one occasion, she was arrested in Baltimore City for sleeping in an abandoned house and detained on an extremely low bail. She was charged with 4th-degree burglary and trespassing of the abandoned house. Within a week, she was offered a plea bargain in early resolution court, 2 years prison, all suspended, and 2 years supervised probation. This was probably done as a benevolent approach to give her a chance to make good to society and get released into the community. She was released into homelessness. She went directly to the same abandoned house, did not report to probation and parole, and was picked up on a warrant after violating her probation, brought back to jail, given no bail as a high-risk offender with a flight risk. And when she went before the judge with the 4th-degree burglary charge for sleeping in an abandoned house, her probation was revoked and she served the entire 2 years prison sentence for sleeping in the abandoned house. She was released again as a short stay offender from the Maryland prison system with no services, no housing, and she left prison after 2 years with no GED and was homeless immediately. We continued to work with her. She didn't violate again, but we were there to try and ameliorate all the many barriers to the supervision that again presented themselves to her because she was also on parole. The next anecdote I'll give you is Mona's story. So Mona was another longtime client of Power Inside, also homeless for many years, addicted, and with multiple chronic health issues. We got her housing in federally subsidized housing as a Housing First model client, and I can talk more about that at another time, that immediately houses homeless people in housing. And she, after many years, her criminal conduct and her addiction waned as her health services and drug treatment increased, but was arrested in front of her federally subsidized housing for an open container as a black woman on the street. She's much more likely to be stopped and arrested. So she was arrested and put in jail. Well, actually, she was given a civil citation for the open container and forgot her court date. She has dementia and she just didn't show. So a bench warrant was issued and she got picked up. It got referred to the warrant task force. 3 police officers entered her apartment building, extracted her, detained her for 10 days. And she was again not given a bail she could afford because she was a flight risk. So from that point, the system wanted to provide a benevolent approach to her detention and her criminal charges and referred her to the homeless docket, though she wasn't homeless. And, we went to court with her, and we're not a lawyer, we can't give legal advice, and I say that to all of my clients. And, but they were trying to reinstate the diversionary court. And so we had recommended that could 10 days be enough? 10 days in jail with a bail, interrupting her housing and jeopardizing her health care and her health, would that be sufficient? So I tell those stories to say all of these women that we work with, well, most of them are black women with a lot of health complications that at every stage of the system, we need to be looking at how to prevent their detention and arrest in the first place. So any pretrial reform must include looking at the judiciary, looking at the prosecutor's role in taking charges of folks that have spent a significant time in jail already, and the defense in allowing these pleas to go forward or allowing the bails to go forward in a way that continues to complicate the lives of really, really low-level offenders. So in terms of recommendations, that would be the first one is to look at the various intersections with the systems that the folks encounter, to end the money bail system outright, because we can't continue to bargain away justice just because we are fearful of failure to appear and violations. So long as the drug war continues and the war against poor people continues, they will continue to be in the system and be what's called higher risk offenders. So we need to approach that head on so that they are removed from the system at the earliest point and given the lowest level of supervision so they're not set up to fail. So that's all I have time for, and I would love questions.
Well, thank you. Thank you to all the panelists for your thoughtful comments and for keeping them concise within the time frame. We're going to open this up now to members of the committee to ask questions. Since there are 4 panelists, I would ask, if possible, if you could direct your question to a particular panelist. I'm not going to ask each panelist to respond to each question, but if you feel so compelled, just let me know, and we'll try to give you time to be able to offer an additional response. We're going to go in the opposite order that we went the last time. So, Tara Huffman, you have the first question.
Thank you. My question is directed to Zena. Could you say more about the steps that need to happen so that preventative detention doesn't continue to be the new default? Now that judges are moving away from bail, what else needs to be done so that more folks are released, judges feel more comfortable, and there's a culture change within the judiciary so that judges are in fact releasing more people on their own recognizance or have a better understanding of pretrial supervision?
So I think you kind of answered that question in your question. You addressed the cultural change, and there needing to be an attitudinal shift in the court system. I think that that's going to be a twofold change, particularly because we already have existing case law out there, and the Court of Special Appeals has the 2005 case on preventative detention. And we also have the Supreme Court on preventative detention. I mean, of course, that there could always be more case law and more litigation from folks like the public defender and our clinic and Doug's clinic as well. That's definitely encouraged to get more issues on fact-specific scenarios. But when it comes to just handling it in the district courts, I think that there needs to be substantially more educational programs on how to administer a preventative detention hearing in general and what kind of information can be taken into consideration. A lot of times we'll hear from state attorneys or even judges that this is defense counsel is turning this into a mini hearing. Well, the case law actually says it's supposed to be an adversarial hearing because it's preventative detention. That means that you are taking away the liberty of someone who is unconvicted. Liberty is a fundamental right, and you are taking that away from someone who hasn't gone through any of the procedural due process protections. That's why it's adversarial. That's why you have defense counsel, and that's why defense counsel has the ability to fight for the defendant, and he has the presumption of release, and that's why the state has that heightened burden. So education around that basic concept needs to happen. And the second recommendation would be going towards Major American, who has implemented pretrial services, having available options that aren't just monetary, that actually address dangerousness, maybe diversionary programs, checking in with pretrial services. Someone earlier in the last panel asked about technology. There could always be, in order to implement a less cost-effective or less costly style of home detention, someone could, pretrial services can call a landline phone and make sure to do randomized calling, and that person has to answer the phone. If they don't answer the phone, that means that they're not there, and that's a violation. So things like that can be implemented in more creative ways. And I mean, the bail is it's an area that is unregulated. That's why it's so dangerous, but it's also, right now, because it's so unregulated, we have the opportunity to be creative and make sure that there are programs that are encouraging the release of people as opposed to the detention of people. And if you'd like to share anything else on that, I think those are our 2 biggest recommendations.
It does. It provides a very good menu for the judges once bail is no longer affordable or unable for a defendant that is passed through a validated risk assessment and it's an objective event, and it allows for that person that meets the criteria, because there's many of them still that don't meet the criteria. They may have a high bail for a reason, and also we still do the risk assessment tool on them based on a point value that's forwarded to the judge and the defense attorneys. And there are plenty of technologies getting better and better. The ankle bracelet that everybody hears about that you see on TV. It's there, it's real, it works. When it gets cut off, and we get people to cut them off and sling them into the woods and drive off, and we can find it, we go right to where it's at. But it's not expensive. It costs me on my vendor, I looked it up last week before I came here, and it's $3.10 a day to have an ankle bracelet on somebody. And so out of my $30 a day to watch somebody, $3 of it, if they're a level 3 or 4, they have an ankle bracelet.
And to that point, does the defendant pay?
No. I'd be paying $150 to keep them in jail. I would love to just pay that $30 and watch them. That's my $12 million budget to run my jail, so why would I charge a defendant if they're going to be in jail costing the taxpayer a lot of money if I can do it cheaper? There's no way I shouldn't be making money in the jail with that program. And we can also say, you know, and my warden that's sitting back there, the ankle bracelet now, we can make it vibrate so the offender knows to call us at the detention center. We want to talk to them right now.
Thank you.
Jennifer Mathis.
So, my question is for Jacqueline. You raised a number of issues around intersecting service systems that basically create complications, even with sort of doing the basic type of bail reform measures that we've been talking about. And obviously, I think, you know, trying to address all the problems in all of those systems goes beyond what we might recommend as a committee, but are there sort of concrete things that you would suggest that could be done within the context of pretrial reform that would actually address some of those issues?
Yeah, I think, you know, I was a commissioner on the Commission to Reform Maryland's pretrial system, and we collected a lot of data, and the data could be reanalyzed to really illuminate a whole lot more than the analysis that was done. So it did not include race and gender, and we didn't really have a lot of control over how the data was analyzed. But we really need to go back into data sets like that and dive right into those that are most likely to fail to appear. Because at the heart of it, we're going to find poverty and behavioral health issues. And, you know, the elephant in the room is always the failure to appear. And, you know, a lot of reformers don't want to talk about the real possibility that there is going to be a certain percentage of very low-level offenders where the failure to appear rate, until we get the health system in the community, you know, fully resourced, that will go up. You know, but there are a lot of community-based organizations like ours and others that could be better networked into the pretrial systems. I know years ago in the state of Maryland, they brought the OCMS online, the case management system, and a lot of community members were on an advisory board for this system. And we talked about having a portal or some way to plug into directly the pretrial system so that referrals could be kicked back, similar to the way the mental health system identifies folks, like a direct link. I think it's called a data link between the mental health system and the criminal justice system. We need something like that for the bulk of the people, because a lot of these pilot programs, specialized courts, pretrial diversion, you know, using probation before judgment, are set up on a pilot select basis. And, you know, I really want to look at the breadth of the population and figure out, like, where's the bulk of the failure, and let's go right into that, because if we continue to kind of split things off by these subpopulations and pilots, we're never going to really get at the heart, the root of how people are cycling through the system. And so, you know, I really want to look at the data. I want to look at the, the law enforcement on the front end to reduce those arrests of people with behavioral health issues. I know that that's a system outside of what we're talking about, but we could look at the data to then kick it back to law enforcement and say, look, we're using arrest, of homeless people with the charge of trespassing that is, spinning the system out of control. Work with prosecutors to start refusing charges that really make no sense to be in the system at all. And to really right-size the burdens of supervision. One of my big fears with the Maryland rule is it has, in the spirit of reform, and it is absolutely a step in the right direction, but in the spirit of reform, it's got a set of possible conditions. And we want to make sure that any pretrial conditions are right-sized and specific to the crime, because we are afraid, or I'll speak from my own opinion, I'm afraid that we will use pretrial conditions in the same way we use preventive detention or pretrial detention in ways that we are trying to express our will or want for that individual versus something that will help them show up or something that will keep them out of trouble or protect public safety. So that's where I draw the line. I don't want conditions that are not appropriate for what the conditions are trying to achieve. So those are just some of the things that I would be working on.
Thank you.
I just
Doris
wanted to
Dow, speak up, please.
I just wanted to make one comment, and that was what you mentioned about, and then I'll have my question. I know that in Baltimore County, the person who has the ankle bracelet has to pay for it. So your people are lucky if you want to pay for it, and I think it's like $40. I got that from the state's attorney. So I think that there's a difference across the state, and that's something that. But my question really deals with the new law, and I thought there was a risk assessment that was to be done to make that triangle, or on the part of the judge, to make that triangle to be like what you thought it should be. And I know that there are programs, I've heard somebody mention on another panel about Washington, D.C., and I heard on a thing that where you were present, about Kentucky, and plans like that. Are there programs like that, like what D.C. does or Kentucky, that are models that we could emulate here in Maryland, that would change that held without bail situation that has now evidently replaced the bail?
Doris, to whom are you directing the question?
Anyone.
When Major American says that he's confident now, or feels good about the change in the system because the right people are in jail, that warms my heart, and because it points to the fact that he's adopted a risk assessment and some evidence-based practices. DC has a preventive detention statute, and the burden is on the prosecutor to prove by clear and convincing evidence that the person to be detained needs to be detained, and that gets to the point, and they release 92 to 95% of the individuals. So that 5 to 7% is about right. It's what the risk assessments across the country will tell you are the high-risk people. So if they're using evidence-based practices, and according to the corrections folks, it's working, then those are models that we can look at. Certainly DC, Kentucky has adopted the Arnold Foundation risk assessment, and there are other jurisdictions as well. But I think that goes to your point, that we, and the other point that was mentioned a while ago is that our jails are becoming de facto mental institutions and homeless shelters. And those aren't the people that are dangerous. Those aren't the people that we want in our jails at $149 a day. But those are the people that we find day in and day out in the Baltimore detention centers, in Baltimore County Detention Center, Montgomery County Detention Center. And it's the correction folks that are coming to the commissions that we sit on and say, let's get it right, let's get these people out of here, let's bone up the health system, let's give grants for mental health treatment and addiction treatment, because we don't want to use our jails for those purposes, and that's exactly what we're doing.
Just to add to that, there are no uniform standards across the state, as you can tell. In St. Louis County, they pay for the GPS trackers. Baltimore City, the majority of counties don't pay for that. Some counties have a pretrial risk assessment tool, some do not. Some have pretrial services, some simply don't have any type of pretrial services. So there needs to be, in general, some kind of implementation, investment into these types of programs that result in non-monetary conditions of release for defendants. And if that includes evidence-based study, that would be very helpful. But there needs to be more data in order to create proper evidence-based studies and in order to create validated risk assessment tools. There's currently a risk assessment tool in Baltimore City. Some would argue that it is unconstitutional. It has proxies for race embedded in them. And even if it was validated, it has an override factor. So my client, particularly that I was talking about earlier, he was charged with a very violent offense. If you put him into the risk assessment tool, he would have been extremely low risk, but for the charge itself, and the charge is what would make him that high-risk person. And that's one of the problems that you want to try to avoid. That's what a good risk assessment tool would help you avoid. It would prevent you from kind of bootstrapping the charge itself to the dangerousness determination. It would separate the two and actually identify who is dangerous based on their circumstances, not dangerous based on the charge. Because if you just based it off of the charge, you would essentially be assuming guilt. You'd be cloaking in the presumption of guilt as opposed to the presumption of innocence, and that is an extremely dangerous and prejudicial road to go down, especially so early in the trial. And as Doug Colbert mentioned earlier, bail really is one of the most critical stages, and I think that that's, again, part of the attitudinal change that needs to occur. Previously, and this is due in part to a lot of prior existing case law from the 70s, that the probable cause hearing is not supposed to be adversarial. You really only get your process, that amount of due process at the trial stage. I think there needs to be an attitudinal shift in the trial as a whole, and to encompass the pre-trial stage and the post-trial stage, and to regulate what's kind of unregulated at the moment. That's all.
Thank you. Jenny Segura,
Yes.
you have the...
I have a question. It's directed to Major American and to Jacqueline. But if anybody else has, they may also offer information. My question is about education and career preparation. I know you mentioned it briefly, Major, but in your jurisdiction, you mentioned something about education, I think GED.
Yes, we can, our case managers that identify these folks, and you'll have some folks that don't have jobs, that, I hate to say maybe not even get a job, but it happens. But if they're not going to do that, part of the curriculum is too, if they've identified, like we have in our jail is a 10th grade education level overall. So when you have these pretrial offenders that don't have a diploma and they're sitting at home and they're on a level 4, we'll allow them to go to GED classes or things like that. Same with employment or employment things, and going to job connections, places like that, and social service referrals. It's, part of your broad thing is, we want you to go get a job. We'd like for you to go and then go there and see what you can find, and then look for a job. So those are things you can be doing while they're on pre-trial too, to motivate these folks while they're sitting there languishing, because we all know if they're sitting at home and then they're up to no good, they're going to go create another crime and stuff. I mean, it doesn't necessarily, if they don't go to that, then we violate them for that, but it's part of the write-up when it comes time to go to trial or whatever, or stuff when Mr. DeWolf here wants to validate his client. Look, he's done everything. This is what the write-up from the case manager says. I mean, if he's going to use the good stuff, he has to see what the bad stuff is too. So we do that too, because a lot of these folks have trouble navigating through a system. I mean, everyone thinks affordable care. Hey, if you don't have hospitalization, you know, it's automatic. We have to go through these places to get that. 10% of our pretrial folks still don't have it when they come knocking at the door of the jail when they come in there. And we have to get them those services in order to be able, while they're out on pretrial, to go get substance abuse treatment. Because when you get in jail and you're incarcerated, it's a backup. You're waiting in line because you know you don't have access to treatment. But if you're on the outside of the fence, man, you're jettisoned right through. We get same day referral. So those are the things that we do with pretrial services with a case manager that your standard, the court system just doesn't have time for that. I couldn't see Judge Morrissey want to raise his hand to do that.
And so for our population of women as well as men who are detained on lower level charges, they're cycling through pretrial detention more quickly than folks with violent charges and are less likely to serve sentences in jail or prison. So there isn't a lot of time to provide educational services. I also think sometimes there is a bias that you can't actually provide literacy or educational services to people with drug addiction or mental illness, meaning that we can only focus on one thing at a time, but as soon as they get out, life is not just one thing, and they need, many of our women need basic literacy. When we did our survey in the jail, 40% of the women had fewer than 12 years in high school, so they didn't have GEDs essentially. And many they hide the fact that they can't read at all. So some of the basic literacy needs are so overwhelming they can't fill out a healthcare application or a food stamp application, and they don't seek services that have to be obtained through applications or very complicated resource lists. So really kind of going from that assumption, we try and ameliorate some of that and assume that there are people in a group this size that cannot read or write and can't probably fill out an application for health care. So we kind of make a presumption that they need that assistance and kind of go into doing that. But when they get out in the community, a pretrial status or you know, maybe on a supervision program that's attached to a probation before judgment, some programs don't really want to work with someone who has open criminal charges or has an upcoming court date. So we've had trouble getting people services, even educational services, that they would be completely appropriate for, but they have disclosed in a very well-meaning way that they have this open charge, and because of the Human Services Program's requirements, they want to make sure they complete. And so we've got people being, not allowed to have, access to education solely because they are in a pretrial status, precisely when they most need support and feeling like things are moving forward. So that is a big concern.
Thank you. George Leno.
This is a question for any of you. If there are constitutional questions involved, then is the Maryland process of permitting each particular jurisdiction to have a different set of rules archaic and probably unconstitutional itself? Should we move toward a single set of state rules so that nobody has to pay for an ankle bracelet, or pick your own example? Or if we did that, would some of the progressive policies that exist in St. Mary's County have to conform to a statewide policy that would be not so benign?
The recommendation of the commission that three of us served on
was that a statewide pretrial system be adopted. Each jurisdiction has their own correctional system. And so that would be a large change. It would be probably a relatively expensive change to do all at once. So the reason why so many jurisdictions are pointing to Native Americans' situation is that it illustrates that it's not a multi-million-dollar change. He was able to take a couple of positions in his jail, shift them to pretrial, and actually end up saving money because it costs more to keep the person in jail than you get the idea. So I know that doesn't address your constitutional issue, whether or not there's equal protection if you're in St. Mary's County and you're not getting your ankle bracelet paid for in your Baltimore County, and you are getting your ankle bracelet paid for in your Baltimore County and you're not. That's something that I can't answer. I don't know.
I can add to that. There is parole and probation has pre-trial monitoring in every state, in every county in the state. But you have to remember something that when I decided to go down this road and we sat on this commission, only half of the counties embarked on their own. And we weren't one of them. I didn't have them. We relied on parole and probation that had some of these folks a judge would order to be monitored while they were out there. But if you talk to parole and probation folks, and no dishonor to them, they have enormous caseloads. And they're on post-conviction. They're monitoring people that are on parole and probation, not pre-trial ahead of the game. So if, say, Johnny doesn't, he tests positive for marijuana or cocaine, it's easier for that probation agent, instead of working with them like my folks have to do, because addiction just doesn't change because you were arrested by the police. It's a violation, and they do a petition to the court, and then the court throws them in jail. So I get them then on a violation of their pre-trial, and then they languish in my system in the detention, taking up a space, wherein my staff, if we're proactive in our community with these folks and get them into treatment, understand part of treatment is relapse. Don't get me wrong, I'm not drinking the Kool-Aid on everything now. But the bottom line is that does happen. If you sit in an adult drug court like I have and like my staff do with Judge Abrams, they do relapse long-term into these things. So you have to understand that. Just because someone relapsed, don't violate them and throw them in jail. But that's the easy button, and that's what we do also. So, and that becomes a cost, and it's not only a cost for me financially, it's a cost to that family and everything else that's going on with them. So, we're talking again, the opioid crisis. We're doing, last week I saw on my, every day I get a brief, every 12-hour shift, and, we had 6 Narcan hits down in St. Mary's in one shift. So, and what 30% I told you are drug offenders anyhow in our systems. So this is pre-trial 2 is dealing with that. And it's very, very tough to detox a person in a detention center. We don't have nurses around there that can just handle that, and doctors. Hospitals don't detox them, send them to jail. So we have to get smarter.
Without answering your directly and affirmatively whether or not that is going to be a constitutional issue, particularly as equal protection applies in each jurisdiction, I would say that Maryland should be more proactive and make sure that there is some kind of uniform standard that does not bring rise to these constitutional issues, because otherwise you'll be faced with a situation where there will be litigation, and litigation might turn you to a remedy that's substantially more costly than what the state intended to begin with. So again, taking advantage of the fact that there is nothing, it's a little bit unregulated and not uniform, taking advantage and filling those gaps now in a proactive way is very critical and important. Otherwise, the remedy can be more costly through litigation.
And I think the rule that's going into effect in July might slowly move the system towards that process, because the judges are going to understand that they cannot impose a bail, that a person cannot afford forward, if the same thing applied to ankle bracelets or other parts of probation, that same inquiry should be made, and perhaps the judges will get in the habit of asking those affordability questions.
Thank you. Gregory Hill.
Thank you. I just want to briefly preface my question by stating that whatever skepticism you may hear in my question or voice is not skepticism of the ultimate goal or even the approach, but more by me playing devil's advocate and trying to anticipate the blowback, I suppose. And so I wanted to pose a question to Professor Mahar, in part because it's fun to pick on my own colleague, but also to Major American. And I want to begin, I guess, like the question with the case that you point out with your client who's there on a serious charge. And the judges make a prediction how dangerous it will be to release into the community. And as somebody who sort of teaches and been in this subject, we usually do predictive value. We have studies that actually, if you say yes, no, it's a pure, yes or no, we actually do very, very poor job at it. That it's thrown, their studies show that flipping a coin actually does a better predictive value than asking, say, a psychiatrist. But so competitive psychiatrists give us probability, right? They say, well, this person, given everything that goes into my evaluation, is 60% likely, 40% likely, and so on. And so, but ultimately the question is, once, even assuming that those predictions, properly done and with allocating proper values, are actually reliable, how much risk should the judges tolerate? You know, somebody says, like, this person has a 30% chance of doing a violent offense while on pre-trial release. In light of the fact that judges in Maryland are subject to election, and if not, people who appointed them are subject to election. And how much is it, I guess, reasonable to ask the risk of community to tolerate, in the sense that at some point community will simply say, look, this is all not working, whether or not they are right or wrong about it, at the end of the day, their responsibility, right? And so that opened that, I guess, is a question Ms. Mahar, and so then the other side of the statement is to Major American, so in your testimony you said the right people are in jail, right? And so the question is kind of the same way, how do you know? Yes, you have data that they're not reoffending, but all it takes is one, right? So you take somebody who is bad, so what would you expect from your community when somebody does, that you think wouldn't do that, they can go down and stab through something, or something along those lines?
By adopting that program, sure, I took on a lot of risk too, me and the sheriff. Okay, a huge risk ourselves by saying, we'll take on this, use a risk assessment tool, and provide the information to the judge. Okay? However, prior to that day, what was happening is Johnny gets arrested, comes in the back door of the jail, gets fingerprinted, photographed, district court commissioner sees him, says, $50,000 bond or something. Well, Johnny's not going to make that, so he sees the judge the next day. Meanwhile, when she sees the judge the next day, Paul's sitting there beside him. And he has to vie for his client and hope all that information that his client's given him is the absolute truth and honest and everything else. And then the judge is making a determination on that spiel that was just given. Now, I don't know how many times you guys see offenders every day around this table. They're not always exactly very truthful when they want to get out of jail. They'll just about say anything. But I have a case manager every morning at 6 o'clock that shows up and gets this information and does the risk assessment, and it's the best that we can do. It really is. It gives the judge and the public defender and the state's attorney the information that we've provided that's accurate and isn't just what he or she says to the client. We have one judge, our district court judge, if a residence establishment's an issue and we haven't verified that yet, she'll just keep them until, let me see him again tomorrow, follow up with this and get back to me on this. Meanwhile, my staff's out there in the field figuring that out for him or her to try to get them out of jail. Not keep them. Try to validate it to try to get them out if they can, but if it's not in the cards that they're going to get out, then the risk assessment is that. Yeah, it only takes one, but if we can show to the public that we are looking into all this information as best possible, the public defender down where I'm at that works for Paul, absolutely, that's the first thing they want to see every day.
million-dollar question, is how much risk should the community have to handle? How much risk is a big enough risk to release, or a high enough risk that you have to keep it incarcerated? And it's a very subjective and extremely hard question. It comes down to the totality of the circumstances about that particular individual, looking at his prior record, looking at the community itself. Does he have a community that will support him and that will take him in? But at the end of the day, I guess I have to ask back another question: how much is someone's liberty worth? Because a lot of these people who are detained prior to trial, they're never convicted of a crime. They don't even get a trial, because oftentimes the state will dismiss their case, and that's where it comes down to pretrial detention being a proxy for punishment. People, misdemeanor cases where you're held without bail, for such a low-level offense, the process costs are more costly to the defendant than a guilty plea taking time served. So it's easier, cheaper, faster to plead guilty, and you just get out of jail. And it comes down to whether it's, the problem is that the state system is just so overloaded with so many cases, and our recommendation would be that prosecutors should really vet the pipeline and vet what cases are coming in, as opposed to asking for help without bail, getting that help without bail, and then dismissing the case 30 days later. That vetting needs to happen much sooner, and there just needs to be substantially more accuracy, and it's hard to gauge accuracy of risk, because the problem that we get, and this is again the problem with having a federal system brought down to the state courts, it is extremely hard to avoid the charge from dangerousness, and it's a problem we have to deal with. But as a community, if a person has no record and no predisposition for dangerousness, and just the charge says he's dangerous, I think that Major American and his team should be able to mitigate that type of dangerousness. If there's nothing in the person's background that indicates he's dangerous, a lot of times pretrial services should be able to mitigate that.
And I just wanted to take a crack at it, the million-dollar question as well, because I think that the answer to me is no more risk than we are already taking with a system that is not reducing violence in the community, is not protecting, in our case, battered women and survivors of sexual assault and stalking, because, you know, prior to working with offenders, I was working with victims of crime, and one of the reasons I started working with offenders in the pretrial system, and women specifically in jail, was that there were more battered women in the pretrial system than in any shelter, domestic violence shelter combined. And so we're already enduring, as survivors, a tremendous amount of risk in the way the system is set up. And endangers us, and so I think we really kind of need to step back from it enough to look at what is currently happening, is that that battered women are almost no more safer than they were 20 years ago when the whole movement began, because we're not stopping the violence, and the pretrial system and the bail system is not stopping it either.
Thank you. Ms. McConkey.
Thank you. Poverty itself is not a protected class. Maybe it should be. But you've been very helpful, Mr. DeWolf, in helping us understand the gaping disparities by race here. Ms. Robarge, also with respect to the impact upon women. And to help us better understand the impact not just on individuals, but upon families and larger communities. Could you, either of you, speak to whether or not these women are mostly single? Do they have children? Is there an impact with respect to age? What age group are we talking about that's mostly impacted by this? And finally, is there an impact or are there concerns to address with respect to Spanish-speaking defendants or others who are not speaking English as a first language?
So I know 80% of women in detention, and this is locally as well as statewide and nationally, are mothers. Many are the majority are the primary caretaker, and with the help of extended family. The children are absolutely destabilized by incarceration and have a tremendous amount of stigma, as well as moving from, one family caretaker to another. And then the process of family reunification after detention or prison is incredibly complicated and skews what is possible for that family. And so it has all the collateral costs of the family welfare system and child custody system. And women in the family court system don't always have defenders helping them with the reunification process. And even a short period of detention can fracture the family for many years to come. And so that is what we know.
I think the significance of the data with respect to the amount of corporate premiums that are imposed on communities and zip codes. And I was thinking about this as we were talking about fines and fees. It just increases a cycle of poverty, not only for individuals that end up owing more money. There was an article in the Daily Record, I believe, about an individual that was paying on his bail debt for 8 years, and he owed more at the end of the 8 years than the original debt was because of the cycle of debt, the interest, and the attorney's fees, and everything else. But then you magnify that by the millions of dollars that are imposed on communities, and you can see, you talked about poverty, and we don't have the answer for poverty, but we can see in some of this data why people get mired in poverty and end up spending their life in poverty because of the enormous debt that the criminal justice system imposes upon them. Someone mentioned Ferguson. There are more warrants in Ferguson for arrest of people for non-payment of debts than there are people. Now, we don't have that same specific problem in Maryland, but the millions of dollars that are owed by the poorest of the poor in our system, to me at least, is eye-opening, explains why so many people remain the rest of their life mired in poverty. So.
Just briefly, any thoughts on age or language?
I know that we have served primarily Spanish-speaking women. We've also served foreign nationals from China, primarily Mandarin-speaking, and we had the kind of unpleasant experience of seeing certain aspects of the criminal justice system using Google Translate to communicate with offenders about their pretrial release plan, and they were immersed in a diversion court, and we advocated very as best as we could to try and get that individual out of the system because it was a complete setup for failure when there was no one that could speak that person's language to actually sit with them on the services that they needed. It was very troubling.
I don't have an answer to your age, but I suspect that you might be able to find it in the Arnold Foundation report from 2013.
Thank you. Pamela Bennett.
My question is for Major American, to follow up on some information you were sharing during your presentation. I wonder if you had any thoughts on why only about 20%, you mentioned that 20% of the intakers in St. Mary's County qualify for pretrial services. And I wonder if you had any thoughts on some of the major reasons why those that didn't qualify. Are there some typically major reasons why they did not?
Yes, actually, I've been pretty intimate with my pretrial services program, but Because of the way the state had their FTAs over the years, part of your risk management, risk assessment tool, FTAs plays a major component in that. And the states had to try to fix that a little bit to understand when we were in a pretrial commission. The FTAs are still haunting those people that are coming through now. I guess that's the best word I can use for it. Their history of FTAs, no matter how we've defined them through the state, when they come into the Miles NCIC on a criminal record check, pop up. So we see that FTAs have been a real big downer for most of them.
That's all right. Thank you. I have a very technical question about something, Paul, that you spoke about. And that is the $256 million in charge, what you call corporate premiums. Is that money that's actually paid? What is that $256 million?
It's the amount of money that was put on the individuals by the judge. In other words, it's an accumulation of the amount of premiums that one would have to pay in order to get out. So you can assume.
If the judge said $10,000 bail, what would be the corporate premium generally associated with that?
It would be $1,000. It would be $10,000. And that would be added to in the 256 million. Now, the individual would need to post $1,000 non-refundable to the bail bondsman. And sometimes they may, for example, take 1%, so they'd have to pay $100, and then they would owe the bail bondsman $900 in debt. That would be paid over a period of time.
So the 256 million, that is the amount of the bail that was assessed then by the judge accumulated.
Yes.
So if the judge says your bail is $10,000, then that $10,000 is what goes into the 256 million calculation.
Yes.
What does the 10%?
It's premium. I'm sorry, I have to get my own data. Yeah, those are corporate premiums that were assessed.
That were assessed. So that's the 10 million. That's the 10%.
Yes.
So the bail that was imposed was essentially 10 times 256 million. The corporate premium that someone would have to pay if they wish to get out of jail is the 256 million. But that some of that 256 million may not have been paid, but instead someone may have gone to jail in lieu of paying.
Or may have been debt. If they may have paid part of it and owe the balance.
Okay, thank you for indulging me. Yes.
And to add to that, the 10% is calculated based on Maryland insurance law that they are required to charge the 10% premium. However, they are allowed, you heard reference to the 1%, they're allowed to make it in installment payments since it is like insurance, if you will. So you can put that 1% down payment and continually make payments on it. And that's how you get this situation that Paul talked about with the individual who was incurring interest because the interest was gathering on it, or payments were late and judgments were made upon that person, which is how it ends up being more than that 10%.
I understand. Thank you. So we have about 7 minutes left, and I know that there are a couple of members that had some follow-up questions. Tara, do you want to ask your follow-up question? We're going to go until 20 minutes of, and then we'll take a short break and move to the next panel. But I hope you don't mind indulging us for about 7 minutes.
My question is to Paul and Zena, if you know, in the population of people that are being held without bail, who are those people? Are they lots of FTAs? Are they in fact people who are scoring high on risk instruments? Are they people who are being charged with more serious? Do we know how that population is disaggregated?
So I think that Paul is looking for that information right now, but I suspect that a lot of that information has recently changed because the jail population, again, since the AG's advisory letter, and you saw that spike in held without bails, it's not that people are becoming more dangerous, it's that more people are being held without bail that really should not be there. And that's, so the jail composition is starting to include people with lesser crimes. They're held without bail and misdemeanor charges. And on its face, a misdemeanor charge isn't a dangerous crime. You know, theoretically, it's not as dangerous. It could be a gateway crime, and maybe there could be good cause and clear convincing evidence to detain someone for a misdemeanor charge. But on its face, often not. A felony is obviously what's more serious. So only theoretically a very, very serious felony who should be detained. And that's also, again, looking at it on a facial perspective as opposed to looking at the as-applied situation. So the composition is certainly changing substantially, and it's only going to, I suspect, get worse based on these trends.
But do we have to, so if it's a 7% increase, do we know who that 7% is?
I don't have that data, and I suspect that perhaps the district court commissioners can hold that data, and that would be really helpful to get, and that goes to adding to the data pool, because again, we only have 4 months of data really on this issue, particularly given that milestone of the AG's letter.
But is it a 7% increase or a 7 percentage points increase?
It's a 5% increase.
5 percentage points increase. So it went from 11% to 16%, which is actually closer to a 30% increase.
Yes.
That question was also addressed to you.
Yeah, we don't know the answer is we don't know who those people are. When I listened to Major American talk about using the risk assessment, I think he and those jurisdictions that use validated risk assessment have a better idea of who their jail population is in terms of risk and in terms of other data. But I think maybe, Jack, you could help. In the commission that we both sat on, there was a snapshot assessment of the population of the jail. And I believe the number was somewhere around 30 to 33% of the individuals that were being held in jail were low
Yeah,
risk.
I'm not finding the exact table, but I do see that no bond, no bond at all prior to the rule change, and this was probably data from about 2 years ago, 14% were low and moderate offenders, and were given no bond at all. So that really is problematic, and then another 14% of the no bond folks were considered higher risk offenders. So that is part of the picture, but not precisely what you're looking for.
Jacqueline, could you tell us what you're consulting there, where your source of information
This is the what's it called? The Governor's Commission to Reform Maryland Pretrial System, and it was an 18-month commission after the Richmond decision that Professor Colbert had much to do with, which was to ensure that there were attorneys at bail hearings. That through kind of a lot of conversation in how is this going to be afforded, and that's the kind of inspiration of reducing costs pre-trial, and some of that was to how to get more people out, and then the bail conversation came about, but we can send that around.
The statistics that you just cited came from that commission's report?
Yes, and it was there was a very large data analysis of who was in jail, and they also piloted in maybe 8 or so jurisdictions the risk assessment tool that was based on the Kentucky model, if I'm not mistaken, that Arnold validated instrument. And so that is available.
Thank you.
You can also find that commission's report on our resource page on our clinic website.
Beautiful. Thank you very much. So that really takes us to just about 20 till. Unless there's one really burning question. Thank you so much for your contribution.
Thank you for having us.
Discussion.
Right, I think that we will get started. We now have another panel regarding bail reform. I think that will present a different perspective on the issue of bail reform that has been discussed today. We have Ivan Bates, who's an attorney with Bates and Garcia, and Nick Wachinski, who is the CEO of Lexington National Insurance Corporation. We do have two panelists. I have shared with them that because of the smaller size of the panel, each would have up to 15 minutes to speak. But I've also been told that they're not likely to take that amount of time. We'll see. So with that, we've been going essentially alphabetical. So with that, Mr. Bates, we'll turn it over to you.
Thank you. Hello, my name is Ivan Bates, and I'm an attorney here in Baltimore City. There's a couple questions that I thought about. Why am I here speaking to you? I'm here to give you a different point of view. I'm here to give you a point of view of what's really going on in the trenches. Oftentimes you have groups and organizations that make rules, and how these rules really being implemented, and they really make sense the way that we have the rules. A little bit about me, first of all. I've been an attorney in Baltimore City since 1995. I was a prosecutor for 6 years. I've been on one side asking people not to have bail. And then in 2002, I started, I was with a defense firm. And then 2006 until now, I'm on my own practice. I've done probably thousands of bail reviews. I've seen it go from one extreme to the next. I'm also barred in federal court, so I've done federal bar bail reviews, detention hearings as they're called. I've done poor individuals, indigent individuals, and I've done individuals that have a load of money to get out. So I've really seen the system. I'm also currently president of the Monumental Bar Association. We help to make recommendations in reference to the governor who should be judges. I've watched individuals who came into office with me as a prosecutor who are now judges. So I have a wide variety and background to understand the mentality of a number of individuals who are on the bench. One of the things that's very interesting, I think, especially in Baltimore City and Baltimore County, where I do the majority of my practice, and I've pretty much practiced everywhere in the state, and in other jurisdictions as well, you have to understand to me two things that are important. How are individuals charged? One, they're charged by the police, who sometimes take out charging documents, and they're charged also by individuals such as general citizens who may be upset or something happened, they go take out charges. For instance, Ms. Bennett, right now I could go to the commissioner and say that we're in practical, you pointed a gun at me, fired a shot, and told me you were going to kill me. I would go down to the commissioner, I would take out charges, and you would be held without bail. And most likely would not get a bail. And why is that the case? That's the case because unfortunately that's the system that we appear to have right now. You'd also have police officers that sit down and they would investigate the crime. And they would sit down and have witnesses and they'd have evidence and they'd go to the commissioner and the commissioner would say, once they had you, the commissioner would give you a bail. Once again, say the commissioner said that the police officers investigated the case and that same set of facts I gave, and there was evidence and there were witnesses, the commissioner would give you a no bail because the police said the investigation, this would happen. And the commissioner would sit down and read the statement of facts that I've written, still most likely give you no bail, once again, because they look at the charges of attempt murder, it's life penalty, therefore it's no bail. Then we'd have the opportunity for a judge to sit down and do the bail review, most likely the next day. That judge would sit down and read the statement of facts, and as my understanding is every single judge says they must accept as true what's in the statement of facts, which means the police statement of facts would be no bail. And once again, most likely, the citizen's statement of facts would be no bail. They would sit down as your attorney and talk about how you've never been in trouble, you have great family ties, commitment, and all that. And that's unfortunately where we are. Because with this new system from the court, this new ruling, the courts are often saying, hey, Mr. Bates, I understand, I hear you, this individual's never been in trouble, great community ties, great job, but really it's kind of on recognizance. I would give them a $50,000 bail or a $25,000 bail, but they don't want me to give you bail. I'm starting to see that more and more now. And, when I see that, it's a very scary situation, because I have a couple of clients that are going through that right now. I'll talk about them in a second. But I also sit down and I've seen that exact opposite in some ways. I've seen a kid, and I couldn't believe it, he's already out on 2 felony drug bails. He's currently out on a violation of probation for a felony drug, and he picks up another felony drug bail yesterday in Baltimore County. The judges say, hey, they want us to release nonviolent offenders on their own recall, so there you go. So you kind of see in the system, like, well, what's going on? This a person in the past would have a $50,000, $75,000 bail because they have, quote unquote, have some skin in the game. Or because they have 2 felony drug bails and they're out, to be 5-202, it would say the presumption should sit down and say you shouldn't release this individual. What I'm trying to say is that the system's a little crazy everywhere we're going right now. I would definitely agree with others and the other panelists that there needs to be some reform, but what do we do? One of the things I think we have to understand, they are judges, they are people. And what does that mean? That means that when a judge such as Nicole Taylor, who's a friend of mine, who's been a judge starting in January, is told by the other judges that, hey, try to give individuals bail, release them on their own recognizance or unsecured bails. And she takes a chance and releases a kid with no criminal history because they're 18, has a gun, has a misdemeanor drug charge, has a handgun possession, and they're out and the officer sees them and he's carrying a gun, shoots and kills them. That judge was scoured by the press. And what that message says is that when a judge takes a chance on somebody and they're wrong, they're going to get it. So do you honestly believe the other judges really want to take the chance on their own recall? I can tell you, talking to them, the answer to that is no. They feel like, hey, if I could give the bail, then hey, I would. I need a little bit of coverage. And call it what it is. This system isn't perfect. However, as attorneys, we know which clients can pay bail and which clients can't pay bail. I'm of the belief that, hey, you have a misdemeanor. I don't really understand why having bail for the most part, except if you're looking at domestic violence, you're looking at handguns. But I'm talking about the kid with simple possession. I'm talking about some of the other cases. Why do we even have bail in the first place? But once again, you also have to understand that every jurisdiction is different. Baltimore City doesn't have the pretrial supervision setup that the other sheriff had earlier, talked about earlier. For instance, one of the things that's very important is that in Baltimore City, you would have the opportunity, Ms. Bennett, to have your commissioner say no bail, to have the judge say no bail. I would have all your information. I would have paperwork showing that you were at work or were here when that alleged incident occurred. I would file a request to the circuit court judge, because your case most likely will be indicted because of a crime of violence, and say, Judge, this is her alibi. The judge would simply sit down and say, I'm denying this request for bail because there is no change of circumstance. It is scary, and that's exactly what's happening. One of the things I really was kind of blown away by was the Senate bill was, I think, Senator Muse had a bill that was 893, and I really liked the bill. I supported the bill because the bill automatically gave an opportunity for a third bail review in the circuit court. Because what happens is if you're indigent, and when you're in jail, you're indigent. I don't care if you have all the money in the world, you can't get to it. What happens is you then have the opportunity to sit down with your attorney, because bail reviews, especially in the city and the county, they happen so quickly, you don't know what's going on, you're trying to get information together quickly. But if you have the opportunity for a circuit court bail review, you're able to sit down with your client's family, say, hey, if you can't do bail, can you do electronic monitoring? In Baltimore City, electronic monitoring is not free. I have a client, I'll tell you about him in a second, he pays $250 every 2 weeks for electronic monitoring. His case will probably take a year. He's a basketball teacher who's struggling to pay the home detention. $6,000. But the judge also gave him a bail of $25,000. He paid $2,500 right away. So every jurisdiction is different. And one of the things that I do like with, and I did like with the Senate bill, was we have the opportunity for that third bail review so I could sit down and fashion a piece that would allow the court to feel comfortable, one, releasing an individual back into the community, that they can sit down and say they protect the community, because the court's going to say my job is to protect the community, but two, also fashion a piece to release an individual to the community that allows this individual to go back to the community, go to their job, where they're living, where they're staying. One of the things that's very important is I do a lot of work in the federal court, and I see the federal system has the funding and the money to sit down and carry out the reform that really everybody would like to see. If you want to take money out of it, I get it, I understand, I see it, 1,000%. But right now, the legislature to me needs to make sure they sit down and put that money to the side. If they haven't done that and put the money to the side, then we need to make sure that we at least have the option of bail on the menu. Because there are individuals. The individual I want to tell you about, his name is Michael Walker. Michael Walker has never in his life been in trouble. He pays his taxes, has an amazing job, working in the school system. He's just the traditional family man. Got married, was at home. His next door neighbor, a guy he didn't even know lived in the block, 4 or 5 houses down, dates his wife's stepsister. Allegation that night, his wife's stepsister was beaten by this gentleman. Next thing, he doesn't know anything about it. His wife doesn't know anything about it. They didn't get a call. However, they see a car on fire and they hear someone shooting out the door. Next thing you know, the police are asking what's going on. They make some identification. They say it's a black male for beer. Guess who's a black male for beer living in that neighborhood? My client. The police go, they sit down, they arrest him. We do a bail review. Luckily for me, when I knew the judge, and I asked the judge numerous questions, I basically begged the judge to allow my client to go home. He's never been in trouble. I have an alibi. His wife is at home with him and his kids. They're watching television. They just happen to live in that neighborhood. And guess what? The judge said, you know what, Mr. Bates, I hear you. I am concerned. I'll give electronic monitoring. However, we have to go through a private company. And you know what? I'm going to give him a bail of $25,000. I think it was $250,000. That would be 10%, so $25,000. So he was able to put the $2,500 out. He's out. He's doing what he needs to do. He sits down and says, Mr. Bates, I'm a coach. I'm struggling. We file a motion to modify the bail piece. The problem here is the circuit court judge automatically says denied. Why? Because there's no change in circumstance. So then I file a motion because my client needs to go with his job to North Carolina. He's a basketball coach. The court says denied as well. I then file a motion back in the district court with the original judge. He says I have to deny it because I do not have jurisdiction because the case has been indicted. The problem is we have a system that nobody's taking control of because the original judge wants to change it for me, and I've talked to him. I talked to the state, and I said, I need to have ex parte communication with the judge right now. I know the judge who's a defense attorney. We talked many times. And based on that, I talked to the judge and said, we don't know what to do because we haven't made this decision. You know, Baltimore City Circuit Court judge is automatically denying it. This district court judge wants to amend it. The problem is the right hand doesn't know what the left hand's doing. Because we do not have that opportunity to have that third bail hearing, we also now taking bail off the menu. At the end of the day, we want to go ahead and reform the system. I would strongly suggest that the attorneys who are there, we know which clients can and cannot pay bail. And we recognize that some judges want to feel more comfortable with bail. You can take it all away, and I think that'll hurt the system, or you can add to what's already there. The system, part of it is broke, and part of it's not. I thank you for the opportunity to talk.
Thank you. Mr. Wojcinski.
Thank you for saying that correctly, because most people butcher it. Good afternoon. My name is Nick Wojcinski. I'm the Chief Executive Officer of Lexington National. But let me step away from what Lexington National is, which is a surety company that underwrites bail bonds for a moment, and tell you a little bit about who else I am. I started my career practicing law in 2006 in the city of Philadelphia, which had reliance on commercial bail and had a movement to reform the system and move away from bail entirely that started in 1984. So I started in the practice of law as an anti-bail, bail reform-minded individual. I sit in front of you today as the Chief Executive Officer of a surety company, which should speak volumes to you as to my mindset and where I've come from and where I'm going. Today we're here with you folks as a civil rights organization, or an organization concerned about civil rights. So I'm going to talk to you about some concerns that I have generally with bail reform as an attorney, generally with bail reform as a person who understands criminal justice process, and generally as a person who understands the complexities. Thursday of last week I gave a talk at Penn University on bail reform to a number of other panelists, and I was asked one question after the panel. In my estimation, in the last 40 years, what has been the single most detrimental decision made by the court system to harm the criminal justice process? without blinking or thinking, my answer was simply the elimination of mental health treatment facilities and the movement of mental health afflicted, drug-dependent afflicted individuals into the criminal justice system. Let me be very clear. Civil rights, efficiencies, criminal justice and fairness, all those words can come out in these conversations as many times as you want to say them, and you will not fix the problem of bail reform until you have a robust solution for mental health and drug-dependent individuals. Secondly, numbers seem to matter a great deal. Let's be realistic with each other. I rely on the Washington Lawyers Committee for Civil Rights and Urban Affairs, which is formerly known as the Current Commission from the 1960s. In 2013, they issued a report called Racial Disparities in the District of Columbia relating to arrests. 8 out of 10 adult arrests for African Americans in D.C. Of the 5 wards that generate 7 out of 10 arrests per year, those wards combined are the home of 9 out of 10 African American persons. 8 out of 10 arrests for disorderly conduct, African American. 9 out of 10 drug offenses. 7 out of 10 traffic offenses. 8 out of 10 assault offenses. Similarly, in 2014, they issued a report called The Collateral Consequences of Arrests and Convictions in D.C., Maryland, and Virginia. African Americans compose 48% of the D.C. population, but in 2012, they were 92% of those sentenced in the D.C. Superior Court. I say all that to say this, which is simply, bail reform is not going to make racial disparities in the criminal justice system go away. In fact, just this past March 16th to be specific, two academics, one from Penn and one from the University of Utah, have said that they find no evidence that bail is set systemically higher for or lower for black defendants. However, the disparity comes in being able to satisfy that bail. And both of those academics have admitted that there is no good empirically validated information as to explain why black defendants don't pay bail as quickly as white defendants or non-black defendants, which includes Hispanics and Asian Pacific Americans. The foundation of bail reform, whether by rule or by legislation, is perceived concern that there are a group of, especially in this state, that there are a group of indigent Marylanders being held unnecessarily in jails while awaiting trial merely for one of a few dollars to pay bail. In essence, the claim is that they're being jailed solely for being poor. Due to criminal justice statistics, these concerns have now been extended to communities of color. This committee convened today to discuss, or asked me to come today. I have a letter of invitation that proves this as a lawyer, if I need to show you I have an excuse. To talk about the implications of the rule. I could spend all afternoon, and Doug knows this very well, I could spend all afternoon going back and forth with you all on criminal justice and bail reform. But today is to talk about the implications of the rule. Let me start at I was initially going to end on this point, but I'm going to start with my ending, in that I agree with Professor McCarr entirely, that preventive detention right now under the auspices of the rule is being abused to such a degree that it's turning into the federal system. To understand bail reform, you must understand history. Bail reform did not start in the 1960s. It started in the late 1800s. When you hear people talk about the history of bail bonding was the initial bail reform. People would come to this country, they'd have a bail imposed upon them, and they would talk about personal sureties or full sureties, where you give a house, a car, a house, a donkey, a horse, something of value to show the court that you would come back. But as you saw immigration peaking in the late 1800s, they didn't have access to resources, they didn't have access to property, they didn't have access to tangible, movable chattels that they could put up as security. And what we then saw is we saw immigrant communities respond by working with each other for a fee to come up with bail money. Irish communities in San Francisco is where it started. So if you fast forward then to 1960, where you look at Robert F. Kennedy talking about bail reform, he talked about bail reform in a world where you had a charge, whatever the charge may be, a presumptive amount of bail that was set, and you had racial disparities that flowed through the criminal justice system that were an abomination to say the least. So what he said is that you cannot have the decision for release or detention be based on money alone. Again, charge, dollar, that's all we look at. Charge, dollar, nothing else. So bail reform 1 in the 1960s talks about looking at attendant circumstances of the defendant, which you do now here in Maryland. Under the previous court rule and under the amended court rule, the judges of this state are looking at a number of other things, including access to financial resources. Then you fast forward to 1984, bail reform 2. What happens is you see a number of folks through the Nixon administration up to 1984 saying that there are too many folks who are being released under bail reform 1 that are committing new criminal offenses. So we need to go ahead and empower our judges to preventively detain defendants. In 1984, the detention rate was approximately 25%. And that was not a judicial proclamation, that was what we'll call a bail set detention, which is high bail, you stay in jail. Period, end of story. It was a 25% detention rate. Come with me to 2010, what is the rate in federal court? Approximately 65% of all cases that are going through the federal system are preventively detained, from start to finish. From start to finish. So badly to the point where the Auditor General of the United States has issued 5 letters of concern to the Attorney General of the United States saying, if you continue on this path, you will run out of funding and the Federal Bureau of Prisons will be overwhelmed. Something needs to change. And mind you, my colleague just told you that the federal system is a panoply of all things pretrial because they pay for it. I practiced in federal court in Philadelphia, New Jersey as well. When I had a client who was eligible for release, who was a unicorn rarity, that person had every single condition paid for and facilitated by a pretrial services officer at the federal level. Now, I say all of that about preventive detention because I agree with Professor McCarty that there is no burden of proof in the existing rule to establish what must the prosecutor show, what evidence, what standard must the prosecutor meet to have that individual denied their most fundamental of civil liberties, which is freedom. And more importantly, what is the process? And she said that there is Court of Special Appeals precedent on this issue. The Court of Appeals disregarded that precedent. The author of the precedent is Judge Joseph Murphy. The case is Wheeler versus State. He came not only to every single provided comment to every single Court of Appeals consideration of this issue, but also attended the legislature. And so in the bottom of his bootstraps said, no, if you do nothing else, you must include clear and convincing evidence, and you must make sure there is an evidentiary hearing before you deny basic freedom. And the Court of Appeals disregarded that concern. Specifically, there was a verbal comment from Judge Atkins who said a detention hearing is not an evidentiary proceeding. Is not an evidentiary proceeding. So that is one fundamental concern that not only do I have as a former practicing attorney, but I speak on behalf of the ladies and gentlemen who work in the bail industry. And I wish people would stop calling it the bail industry and start calling it the liberty industry, because our best interest is to ensure people get released accountably. We are not in the industry of keeping people in jail. We are a liberty-based service. Let the person out accountably. Now, as I move from detention through the other pieces of the rule, I want to talk to you basically and principally about the rule. The Court of Appeals adopts a principal rule of construction that requires a judicial officer to promote the release of defendants on their own recognizance or unsecured bond. This is a positive change and is centralizing the new rule, but it is something that has existed on Maryland's books for years. It is not new. However, the rule also states that if release on own recognizance or unsecured bond is insufficiently determined by a judicial officer not to meet the concerns of reappearance or reoffense, then that judge may impose a condition, and that the condition imposed should have preference given to an additional condition without financial terms. Oddly enough, the rule fails to define what an additional condition without financial terms is. There's no such thing under this rule, folks, as a non-monetary condition. If you turn to the definitions, 4-216.1A7B talks about the definition of a financial term condition of release with a financial term. And it specifically states that examples of a condition release that is not a special condition of release with financial terms is an ignition in or out program, an alcohol consumption program, and a GPS monitoring program. You heard my colleague tell you about his client who's paying $250 every 2 weeks to pay for the GPS monitoring device. These are not conditions without financial terms. But let's turn for a moment. Whether you're looking at the indigency concern of bail or you're looking at the indigency concerns of folks who are sitting in jail because they can't pay, $500 a month does not solve that problem. If you look at Defender DeWolf's numbers, where he's talking about 17,000 people on a bail of $5,000 or less. Under his auspices, that's a $500 premium payment to a bail bondsman. Folks, $500 a month, $500 one-time fee. Math's simple. It's $6,000 for the ankle monitor. It's $500 for the bail. The end result of both of those systems is that you have accountability to bring the person back, one way or the other, because that's what an ankle monitor does. Most devices do not stop recidivism or stop victimization. Now let's talk about for a second what an ankle monitor means. It makes it much more difficult to obtain and keep a job. It adversely affects personal relationships. It is a serious deprivation of the plaintiff's personal and individual liberties. I didn't say that. The United States Department of Justice did in 2011. Among the other burdens, the plaintiff must endure pain and discomfort from the bulky heavy device, must sit next to an element for multiple hours a day to charge the monitor, may not fly in a commercial airline, cannot swim in a swimming pool, suffers severe social stigma if he exposes his ankle bracelet in public, and automatically transmits every movement of his life to the state. Living with an ankle bracelet, published by the Marshall Project, July 16, 2015, also highlighted by the Quiet Horrors of House Arrest, Electronic Monitoring, and Alternative Forms of Incarceration, Mother Jones, January 22, 2015. Ankle monitors have been described as a modern-day ball and chain by the Southern Christian Leadership's Conference President and General Counsel in Maryland this past session. It's been described by the modern-day scarlet letter by the Department of Justice under Eric Holder's tenure. There's an abundance of anecdotal evidence. I'm going to, in the interest of time, forego those we heard from Attorney Bates as to what he's experienced. For those defendants who experience home detention and other bail alternative, keep in mind that freedom from being prisonized is a basic constitutional right and civil liberties. Monitorees may be subject to warrantless searches and drug tests where pretrial officers may have ready access to their homes. Every confinement of a person is imprisonment, whether it be in a common prison or a private home. When a man lawfully is in his home and he's prevented from leaving the room where he sits, that is confinement. That is Wallace versus Cato, issued by the United States Supreme Court in 2007. I come here today not based on my own opinions and speculation, folks. These conversations have been had time and time again. Drug testing is a non-monetary condition that has been discussed heavily, and discussed as an alternative to bail, and as part of a probation or supervision in lieu of bail pending trial. Mandated drug tests are another item that can be turned into a cash cow. Again, not my words, it's just Mother Jones. $25 per test, $1,250 for the period of time where a case is exceeding 1 year. The Fifth Circuit Court of Appeals noted decades ago, there are few activities in our society more personal or private than the passing of urine. Yet in many workplaces, in many circumstances, law enforcement visits and the pretrial and post-conviction phase require not only the officers doing supervision to listen to, but also to visually monitor the passing of urine for a drug test. The Minnesota Department of Corrections gives the following staff administrative directive. Staff must position himself or herself in such a manner as to verify the specimen as it passes from the defender's body into the specimen collection container. Again, folks, these services are not free. These services are not free either from fiscal, financial, or human costs. And as we navigate them, I encourage you to understand that bail is 3 centuries old in the United States. Most of our states have had a right to bail at the state level since the founding. It does have a value. It is not the only mechanism. It is not the only release condition. It should be on the menu, and it should be considered, as Sheriff Mike Merrick reported today, it should be considered for those who can, allow them to, and for those who can't, come up with a solution. All at the same time that you look at alternatives for mental health treatment and substance abuse treatment. Thank you. I swore I thought I would be done in 12 minutes.
You packed a lot in.
Wow.
Thank you. Thank you to both of you. Following the last process, we're going to start with questions, and Doris, we'll start with you, Doris Cow.
Well, I would just ask what I was thinking about. But I will ask, Mr. Bates the question. You mentioned, you started with your story about, Judge Nicole Taylor and the case where she didn't impose bail and the, young man went out and shot someone.
The police officer shot him when he saw him with a gun. He told him he wouldn't do it, and the young man was killed.
How would having imposed bail have changed that situation?
A couple things. You could have potentially, would he have made the bail? I think the bigger issue was we should be releasing these individuals on their own recognizance. I think the bigger question was not necessarily that case bail per se, but this is an individual that maybe we should be holding on to. I think one of the things with the bail is you do have a bail bondsman, there's some oversight and things like that. This young man was just running around the streets. I think at that moment in time, the judge would have sat down and said, hey, by imposing a bail, this young man was able to make the bail. So because they were able to make the bail, then hey, they were able to go out to the community.
But we're talking here, if I mean this, but you were talking about bail.
Yes.
And you were talking about not the issue that this option of releasing him on his own recognizance is still on the table. So she had that option.
That's the option she actually took.
That's the option she took, and part of that, the philosophy was, hey, let's try to release them on their own recognizance, if possible. So what happened the first time he was arrested for the handgun, where normally, having done it, your bail may be $50,000, no record. The second case, he has a drug case. Then you have another bail you would potentially, if you're going to release him on, a $75,000 or $100,000 bail. So the belief is, if you're going to hold him his own recognizance, or if he's been continuously paying bails, he can't keep paying bails. Eventually, it's going to go out in the streets. And that was pretty much, I think, one of the issues in looking at that, because I think she felt that she had to release him almost on his own recognizance. I think she gave him a $250,000 unsecured bail, which is basically your own recognizance. The unsecured bail is something that's really new since the order came down from the Court of Appeals. Before that, there were not unsecured bails.
If I understood what you said, was that had she, my understanding, and the basis for my question was that had she released him on bail,
yes,
she wouldn't have been so criticized.
Let me take a shot at this.
That was the basis of my question.
There's two things that I think we're failing at. And Ivan and I have talked about this particular case in many conversations. I agree with what he's saying. He said the fundamental flaw with the system when the judge made that decision is that we moved away from, let me look at all the menu options and impose the appropriate menu option for accountability and reappearance. Instead, she came to what's called a release or detain decision-making theory, which is, if I can't hold him, there's not enough here necessarily to hold him, I'm going to release him on his own recognizance, which breeds a certain culture of disrespect in certain circles of the criminal justice system. Now, you asked, how would bail have protected against him being killed? Let me answer that question from a different perspective, and it's understanding how bail is satisfied. So Judge Bates tomorrow arranged me and gives me a $250,000 bail. As he properly pointed out, everybody in jail is quote-unquote indigent. They have access to nothing. It's incumbent upon their support system to either put money on the books so they can make phone calls, they can get things at the internal vending service, they can get other things that are done. Long story short is, that's how bail is set also. You can't just post your bail on your own. You need to call mother, sister, father, brother, friends, coworkers. Someone's going to have to come in and say, I'm willing to put, and let's be realistic about this, it's not 10%. It's, in Baltimore City, it's an average of 1% down in payments over time. I have to put the initial payment down. And then there's a circle of accountability through family members and friends. And I've heard criticism after criticism after criticism of folks saying that inspires nothing. It's simply untrue. In addition to being a lawyer, in addition to being a CEO, in addition to being a father, the wife of a crime, I'm not the wife, she's my wife, the husband of a crime victim, and I mean a violent crime victim. I'm also a formerly incarcerated, arrested, and processed individual. I don't feel on a DUI. And I can tell you the only reason that I straightened up and flew right, because I like to drink and I like to drive. And those two go together if you're not making the right decisions. Is having to face my grandmother and explain to her what I did and asking her to support me. So when Ivan says to you that the release or detain model didn't work in that circumstance, he's right. But he's also right when he said, don't criticize the judge. So I agree with his description. He's completely on the money. I wanted to answer from a bail-specific underwriting.
The other thing I would also say to piggyback on that, there is a mentality with the young guys, the criminal element I represent. If you constantly let them out, they don't have any skin in the game, so it's just a revolving door. That's how the juvenile system is to them, so they're just going home. But when they're already out on 1 or 2 bails, they're like, look, I can't do anything because if I can get arrested again, I'm gonna be detained. And so I think it's also the mentality. I think what has to happen is to really make the system work, I think sometimes you have to understand the criminal mentality of the criminal element. And this is an 18, 19-year-old kid. He's running around wild. He doesn't understand he's running around wild. If your grandma or you're one of his friends or his brother, you know, who's put up bail money, you're eventually going to say, you know what, you need to sit down for a second so we can get your mind straight. I think bail also allows the family to decide, do they want to pay the bail to have you released, or do they want you to sit down for a second so you understand where you're going? There are too many kids that I've represented who've never done a single second in jail, and then all of a sudden they're in jail for 5 days, they're crying. Where sometime if they're sitting in jail pre-trial, they're like, you know what, this life really isn't for me. I have a lot of those kids as well.
Jennifer.
So I guess I wanted to ask, since I guess Mr. Wachinski, you mentioned that you agree with Professor McCarr that actually with the new rules that in fact more people are being detained. Professor McCarr said, among other things, that there needs to be more education of judges about what the options are that are available to them as alternatives. I guess my question is for both of you. Do you agree with that? That it's, you know, a matter of education, and if not, why not?
Your man's up to you. Sounds like I never sleep. I'm also a judicial educator, so not educating judges is something I'm never going to say. Always educate your judges, always educate your lawyers. But that said, it's not the solution to detention. You can educate all day long about the alternatives to incarceration, the alternatives to bail. Unless they're properly funded, they're properly available, they're ready to go and ready to be implemented on a moment's notice, forget it. Ankle monitors that have a cost of $250 every other week, that's not something that's ready to go. That's just a cycle of indigency. That's it. You're trading one fee for another fee. It's not going to solve the problem. What you need to look at doing is educating judges. First of all, let me back this up. Fix the rule. Put in the burden of proof. Put in there needs to be an evidentiary hearing. Follow federal law, because right now I would argue strongly, and I'm not completely sure that Professor McCarr or Professor Kohler would disagree with me on this. Under federal law, I think that the rule as passed by the Court of Appeals is unconstitutional. It doesn't have the burden of proof. It does not have a companion speedy trial component as required under the federal, similar federal statutes and federal case law, and it does not have any evidentiary access. Other states that have shifted to the detain and release model have very heavy evidentiary rules. They have very, very heavy procedural rules, and they have a standard of proof. That needs to go in the rule as a bare minimum. And then educate judges how detention is to work. And the detention is an absolute last resort, and everything else that should be on the menu going forward. But as judicial education, I think it works for what is a detention, what is not. I think it also works for preference for release, as it relates to bail alternatives, until they're viable, and unless they have any costs associated with them, don't call it a bail alternative, because it's just simply not. It's just another service with another fee.
And as far as sort of viability, I guess, apart from costs, your main concern is sort of the things you talked about ankle bracelets.
You can't get away from that. It is inarguable that these are certain deprivations of liberty. And I have, oddly enough, again, I said I lectured last week at Penn, I had dinner with somebody that I would have called an absolute bail reformer who hated every point of view I had just simply because of who I work with. And she shocked me in saying that these intense conditions such as an ankle monitor, drug testing, home detention, those are not alternatives to bail, those are alternatives to detention. That's a world of difference.
One of the things I don't think people realize, in Maryland, if you're on electronic home detention, that counts as credit for pretrial incarceration. So let's say my client has a handgun charge and I would get them released on bail, and the case kicks around for 7 months, and so the sentence is a year, hypothetical, 7 months, boom, right there, he's done in pretrial incarceration. Because in Maryland, being on bail counts as pretrial incarceration. And I think home detention it's good sometimes, it is. But I think one of the problems, you have to really sit down and look, can people really pay for it? One of the things, I'm a real big advocate, we could have that third bail review in the circuit court, then educate the judge. We can sit down and say, look, this is what this person can or cannot pay. This is where his mother works, this is where he would stay, this is the job he or she would have. We've been able to find them a job. This is how we're able to take them out of the community where his friends are, hanging on the corner, maybe selling drugs, and you know what, he's gonna stay with his aunt over here in Woodlawn, and he has a job, or he's gonna go back to, he's gonna sign up to go get a CDL license. It's something. You've been able to grab that young person's attention quick enough to say, you don't wanna be here. Within 30 to 60 days, we brought you before a circuit court judge, and we're able to lay out, this is why the state's case isn't that great, but Your Honor, but even so, this is why you should be able to release this individual. Maybe it's a small minimal bail, maybe it is whatever, this is the job, they're working, this is who this person is, this is who the family is, this is the support system they have. And I think that would be interesting and important in terms of educating the judge, because a bail review is like that. If you ever go in Baltimore City on a Monday morning at 9 o'clock, the poor judge has a whole group of like 20 people in yellow jumpsuits. They all look alike, pretrial's going through the process. What people don't realize, pretrial's often saying, no bail, Your Honor, no bail, Your Honor, no bail. Because pretrial doesn't want to sit down and say, we released Joe Blow, and Joe Blow went out there and robbed and shot somebody. The problem is everybody in the system, to me, almost appears to be afraid to make a decision to take a chance on somebody else. And that's really what I think is starting to happen. So you have the have and have-nots. The haves are, you know what, this person's 18, 19 years old, no record, I'm gonna take a shot on him. Then you have a person who's been to prison, maybe served 12 years for attempt murder, something they did when they were 17, works and is trying to get on their feet, and you know what, they're in a car with 4 of their friends and there's a gun in the car. The judge's gonna sit down and say, I'm holding you without bail. Why? Because I'm looking at your background, I'm looking at your record. They're not willing to take the risk of a chance on that individual. Where maybe in the past, I would have considered the judge can give him $50,000, $75,000 bail, because this person doesn't have a job, we can at least take the chance on this person here. Stable environment, they're not a flight risk. So the court's gonna say, are you a flight risk or are you a threat to the community? The judge can always find a threat to the community if they want to. And they do more times now than ever before. And to me, it's extremely frustrating, because you need to take a chance on the individuals to turn their life around.
Jenny Segura.
Oh, yes, my question pertains to a statement that you made, Mr. Wyszynski. You said bail reform will make racial disparity disappear.
Will not.
And I wondered if you could speak to that statement a little more, elaborate a little more on that. I know you had a lot to pack in.
It's an easy answer, and thank you for the question. Washington, D.C. and the federal system are described as the panoply of, or the synergy of all things bail reform, which is bail alternatives are funded, risk assessment tools are utilized, and preventative detention is used in a sparing fashion. Then one would assume that if bail reform furthers the racial biases in the system, that you'd see fairer results. Washington, D.C. shifted away from the use of quote-unquote money bail, which I think is an awful term to use, but they shifted away from its use in the 1990s when the city was taken over by the federal government in a bankruptcy issue. Federal government funds DC pretrial, which is why it's so functional. But that being said, they are the E-chain of pretrial. You assume to see a fair result, and 92% conviction rate of 92% of their convicted rate of folks are African American with 48% population. That's not a fair system. That's a system that has racial bias in it, and it's not furthered by bail.
Is it the judges?
I don't have that answer. I would suggest to you no. And I will suggest to you that all day long because I have not, in my career, had the experience of seeing a judge when because you are a racial minority, I'm going to do X, Y, and Z just because you're a minority. Now, I will say to you, don't lose the statistics that I gave you, that the 5 wards that generate 7 out of 10 arrests, those wards combined 9 out of 10 African American, and I'm not suggesting that they commit more crime. Oddly enough, if you look at the Metropolitan Police Department complaint logs, the complaints for criminal activity in those wards are higher than in other wards. I don't have the answer as to why. I simply don't. I wish I did. If I did, I'd give you a whole different recommendation. But my point is, when folks sit here and they say that bail is racist or that its use is racially motivated, just because something is sequentially related, meaning bail is set, people can't make it, and there's a racial disparity of folks that can't make it, doesn't necessarily mean that because it was set in a racist, biased way. So again, just because there's a result does not mean it's connected.
I think, if I may, I think a lot of that also in the state of Maryland depends on your jurisdiction. I can tell you, I go to some of the jurisdictions outside of Baltimore City. It's a little different when I'm an African American client as opposed to a Caucasian client. I think in Baltimore City, what you see oftentimes, the judges are looking at the charges and they're looking at your background. So I think based on your background, is a discriminatory view of who you are as an individual. Yeah, I think, and sometimes it is. But I also have to sit down and say that when you sit down and you do look at race, I think once again, definitely the jurisdiction, but also I would have to sit down and say, it depends on the crime. For instance, if you have an African American accused of doing something to a Caucasian woman, 9 times out of 10, they're really not gonna get bail. I'm not gonna be honest. But if it's an African American or African American, then yeah, I think I'll probably get bail. And I think you have to really sit down and look at the victims and things like that, because then look at the crime sometimes a little different. And those are some of the things that I think I have kind of noticed just going around the state. And I think when you sit down and look at Baltimore City, where the graph showed the number of individuals being incarcerated, a lot of times it's just a record. You know, you have a man we have a case now with a guy who's charged with a handgun. I'll be in court for tomorrow. His underlying felony was a drug charge in like 74, 75. And they still want to hold that against him in 2017. And when you sit down and look at the record, I think the discrimination isn't necessarily always on the race per se, especially in Baltimore City, but they're looking at the background of record. You're almost to a point, well, when do they outgrow their record? You know, that's from the 70s. And so I think you have different ways of looking at discrimination, just not in terms of race.
If I may, 2 small, quick points on this, and that I can brought up. If historically the system is biased against racial minorities, then any decision that is predicated on prior information, prior data that's been collected, is going to be inherently racially biased. We can agree on that.
Yeah.
Now, you look at a professor from Penn, Richard Burke, who talks substantially about risk assessments, and Richard will tell you on the risk assessment there's 2 dials, one for fairness and one for accuracy. As you increase fairness, accuracy is decreased. As you increase accuracy, fairness is decreased. Now why is, again, Professor McCarr talked about a risk assessment tool in Baltimore City that accounts for race and there's certain concerns about that accounting. From a fairness and accuracy perspective, I would suggest to you that most of the risk assessment tools are not science. It's not some it's not a chemistry or physics equation that goes with it. It's a statistical analysis of prior arrest trends. And if there's race bias in those prior arrest trends, then that may translate into the risk assessment tool. There's several criticisms of risk assessment out there, which again, I come back. DC has a 70 or 72 point risk assessment. The Arnold Foundation is 9. So it's just one thing to take a look at as you navigate these waters. And again, that's not me, those are other educated folks talking about it.
Thank you.
Thanks.
George, you've given us a lot to think about. Thank you. But there's one part of the bail process that we just haven't had testimony about. if someone secures a bail bond and is unable to pay it off properly, or doesn't show up for trial, what powers does the bail company then have?
I think that's a big.
Yeah, that's
Those are really two questions, and I'd like to start the first question with the process issue. And that is, so we all agree that payment plans are a viable resource to make bail more palatable, or more, most of your defendants are cash flow strapped, cash strapped. My family, when I went through the process, would have struggled to make a bail bond in one flat payment, but because of an extension of, and I want to call it credit because that's the wrong term, because there's installments that are afforded, it makes the ability of it a little bit easier. So what happens is you make those payments over the course of a month. I want to dispel one rumor right out of the gate. I don't know of a single bail bonding company in the country, let alone Maryland, that is a premium financing authorized federal provider. Which means that when we give those installments, those come into us, Mark, what's the right word here? Interest-free. We cannot charge a financing question on it, a financing fee on it. So it's $100 every month for however many months it is. The only time interest attaches is after we are statutorily required to collect on it and file for a judgment. And again, as Professor McCarr pointed out, that's not our option, that's the Maryland Insurance Administration's option. So you said, what happens? If they fail to make a payment, we engage in collection activities, and there's a certain point in the process where we are statutorily obligated to follow through. Now, in many instances, even after we follow through and obtain that judgment, we still ask the question, how much can you afford a month? Because we're not interested in strapping people. Now, you asked the question of what happens if someone fails to appear. If someone fails to appear, we have a legal obligation to the courts as our beneficiary of the coverage to bring the defendant back. If we cannot bring the defendant back, we are required under Maryland law to render payment in 180 days. First, it's an initial 90 days with a 90-day extension. We must make payment in 180 days. Even after we make that payment in 180 days, during that period of time we're searching, we have a 10-year right of remission where if we find the defendant anytime in the 10 years, we can get all of that money back. Now, one of the mechanisms that we can use is we can ask that the collateralization of the bond, there are defendants' families are contractually obligated to pay for the full amount of bond if they abscond. I can tell you that in my experience in industry, we've never once done that. Not for the full freight of the bond, and specifically, the biggest criticism is that we take houses. I've never seen a house taken. My general counsel sitting right behind you, have you ever seen one taken in your career? Not in this state, for certain, not by us.
No.
So,
If you're hunting for an absconder, do you need a warrant to go into their house?
we do not need a warrant to go in their house because we have, again, private contractual abilities. Now, as a general best practice, we don't force doors and we don't do that kind of collection. In Maryland specifically, almost unilaterally, we locate the defendant by putting eyes on them, by making sure we have visual confirmation, and then we coordinate with law enforcement. In fact, during the legislative session, Scott Schoenberger, who is the state's attorney for Baltimore County, said flat out that the bail industry is one of the best warrant recovery units that he's ever seen because of working with law enforcement and doing things safely. It's unsafe for us to do it as an industry, it's unsafe for the defendants, it's really not necessary. Confirming that they're visually there, working with law enforcement accomplishes the exact same mechanism and avoids the cost of investigation, which can be substantial. The other benefit as to dealing with absconders is if you have a defendant that runs to Pennsylvania or runs to California, we brought a relatively moderate risk gentleman back from Beverly Hills this year. We located him, put that person into a California correctional facility, was brought back, I believe he was extradited, right? Was extradited through the appropriate channels back to Maryland. So that's really where the benefit comes in.
To me, that's one of the problems that I don't see with the rule. On the federal side, they have the marshals. So if you don't show up, but on the state side, if you're released on your own recognizance and you don't show up, they'll find you when they find you. And at least when you have a bail, then you do have someone who would have a vested interest in making sure they find you. And I think when you sit down and you look at the rule, that was one of the criticisms that I had with the rule. because it doesn't say, hey, the police department needs to go and do this or do that in Baltimore City and sue the sheriffs. I mean, yeah, they may have an FTA warrant for you when they find you, but it's not as if they have that much of a vested interest, because there are thousands of FTA warrants in Baltimore City. But on the federal side, because they do have the marshals will find you.
One footnote on the recovery work and on law enforcement generally, as you navigate these waters, as DC comes up in the conversation, understand in addition to the $67 million pretrial budget, understand that the warrants are enforced by the United States Marshal Service as rule in DC. Their jurisdiction is 6 miles square. They have one courthouse, and here's one that blows my mind every time I hear it. They have 21 law enforcement agencies that serve that jurisdiction. So 6 miles by 6 miles is served by 21 law enforcement agencies.
Thank you. Tara Huffman.
So, I have several things rolling around in my head, and I know I only get to ask one of them. So I want to talk about a matter of policy as opposed to practice. So, as a matter of policy, the court rule that goes into effect on July 1 does not eliminate or prohibit the use of bail as a matter of policy. Is that correct?
Matter of policy does not eliminate bail.
And as a matter of policy, the court rule that goes into effect on July 1 does not mandate any particular condition. It leaves that up to the discretion of the judge.
On that, I would substantially disagree with you. First of all, let me start with my baseline disagreement, which is that the rule is going to go into effect July 1st. I believe that rule will be in full force in effect right now, based on the October 26th advisory memorandum that was sent by Chief Judge Morrissey to the judges. While the rule was not passed yet, I think that the general auspices and flavor of the rule are in effect, and I think my colleague rightly agreed with me. That being said, I think that the preference given in that rule of construction to conditions of release without a financial term absolutely creates a mandate, top-down mandate, or at very minimum, I believe it to be perceived as a top-down policy mandate that they should rely on anything but bail when they're making a conditional release. Now, does it specifically contain a black and white mandate on the four corners of the document? Absolutely not. But again, implementation when it comes to policy is very important.
So you have a follow-up to that?
I did have a follow-up to that, but it's a totally different topic, so I'll yield.
Okay. Pamela Bennett.
Yes, so, I'm not an attorney, and I have a little bit of trouble keeping track of, your point, and I wanted to make sure I understood it, so I'm asking for clarification. About what it is that is achieved with the third bail review hearing that is not achieved in the first and second one that you find troubling.
Okay. When you're first arrested, you go see the commissioner. And I think Professor Colbert helped pass the law, if I'm not mistaken, that allowed to make sure you had an attorney with the commissioner, correct?
It was case law.
And
It was the Court of Appeals.
Court of Appeals.
Ruling, yeah.
Exactly. That says so you go see a commissioner. You see a commissioner probably within 12 hours of being arrested. The commissioner has your paperwork, and the commissioner must accept as true what is written in the statement of facts, whether it's written by a regular citizen or it's written by a police officer. Within 12 hours or 24 hours of that, you see a judge. So you may have your first attorney, and they're trying to gather some information. Then your second time you have a hearing, you may have a little bit more information, but it's probably still for a 24-hour period. You don't have that much information. The district court judge, once again, is accepting as true everything that was written in the paperwork. You don't, for instance, pretrial may reach out to your mother to confirm that you have a job, but your mother's working. So if pretrial doesn't talk to your mom within that 24-hour period, they'll say, hey, we reached out to Ms. Bennett's mother and we didn't receive any telephone calls. So everything is done so quickly that you don't have time to really vet out and see the type of case it is. You don't have time to vet out and see, okay, Ms. Bennett, yeah, it doesn't show that you don't have work for an employer, but you know what? You drive a food truck that you own, and you have children, and you take care of your children, your child's in private school, you paid so much, this, and you're married, and all those things that you may not have information the first time. Plus, the other thing it does, you have the opportunity to vet out a little bit more about what this case is really about, to sit down and say, you know what, I have an alibi from Ms. Bennett, and therefore, because I have this alibi from Ms. Bennett, Your Honor, the case that the state thought they had is not nearly as strong as it appeared at the original bail hearing. But because there's a belief that there is no change in circumstance, for instance, change in circumstance would be you were charged with attempt murder, and now the charge is first-degree assault. I would argue that's a change in circumstance because the penalty went from life to now 25 years. So therefore, the judge would allow me to have a bail hearing and would be able to listen to everything. But let's say the jurisdiction is just going to go ahead and indict you on the regular charges. There is no change in circumstance. Even though we know our case has changed, even though I've had the opportunity to meet you, sit down, talk to your family, have your tax statement to show that you're self-employed, but your taxes show that you're working. And that to me is why a third bail review is paramount. Because then I can sit down and say, Your Honor, my client can do a $50,000 bail. You've spoken to this bail bondsman, they can do A, B, C, or D. If it's a very, very violent case, then I can sit down and say, Your Honor, my client can do what I could put together the package that would make the court feel comfortable because I've taken the time to figure out who you are and why you're not a flight risk or why you're not a threat to the community.
I wouldn't call it bail, I would call it a release or detain review, because that's what it is right now. We're gonna detain you, or we're gonna release you. We're gonna figure out how to craft it in order to release you. One of the things I'll highlight and piggyback off of Ivan is early on the books, you got bail set, 24 hours in arrest. Bail review, 48, within 48 hours after that. On the books right now, on a week-by-week basis, a district court judge is supposed to be reviewing who's in jail and why are they in jail. But the bill that Ivan referenced did, what it did is got rid of a facial denial. So he files that, he's gonna get me out, he's gonna file a third bail review in the circuit court. The judge can right now just say denied, nothing's done. What the bill did is it said no. If they're in jail after a certain number of hours after the bail review in district court, they shall be given a third bail review if there's any articulation of a change in circumstances or information wasn't properly considered at the initial, and we have to have a hearing on it. So what I just said is, we're gonna give you automatic and due process third challenge. It was a great tool.
Yeah, I really like it, because also if you're indigent, you can sit down and say, Your Honor, you set a $75,000 bail, my client can't meet it. I was recently in Baltimore County where a judge, who will remain nameless, gave my client a $25,000 cash-only bail that he must provide himself. There was no way it could ever happen. So then there was another judge, who was an older judge, who was a more senior judge, sat down and we had an arraignment, and my client, actually I went and asked for an advanced postponement, that I needed more work to do on my client's case. It was a drug case. And the judge says, Your Honor, Mr. Bates, you want a bail review? I said, yes, Your Honor, I do. He said, okay, come back next week. And he said, and we're doing it. So the argument for him was like, is your client indigent, he can't make this bail? Yes, Your Honor. So if you can sit down and say your client can't make the $50,000 or $75,000 bail, you can have a third bail review to say, Your Honor, my client can do $10,000 bail. He's already spoken with the bail bondsman that worked that out. So that to me is beyond important. Because it's just not fair. I can't tell you how many times I get turned down to have people that have real serious issues. You know, I think one of the things we talked about, you have so many cases that don't result in convictions because you're able to find out things. Why can't we just have a third bail review in the circuit court? That's all I was asking for.
Thank you. Jason McConkey.
Thank you. I think it's clear that bail reform does not comprehensive criminal justice reform make, and that even addressing significant legitimate issues with respect to bail leaves in place many critical issues with respect to criminal justice reform having to do with race and many other issues. Assuming that bail reform needs to be addressed and discussed and legitimately changed if necessary. My question to you, Mr. Bates, as a former prosecutor, is how do you meaningfully bring prosecutors to the table and put their hand to the fire so that they participate in bail reform discussions and addressing those issues? And I cite not only your comments today, But Professor McCarr's comment that one, the chances of, it's 4 times greater for a defendant to plead guilty if that defendant is being detained.
Oh, yeah, all the
And
time.
so, you know, assuming that prosecutors are seeking convictions and guilty pleas, and assuming, you can correct me if I'm wrong, that prosecutors are not as motivated to participate in bail reform discussions, how do you bring them to the table?
I think the first thing we have to understand is you can't arrest your way out of what's going on. And I think when you have to sit down and look at that mentality, but I think you have to do it in small bites. Okay, let's not even talk about the violent crimes. Let's not even talk about that. Let's first get them to admit in terms of the misdemeanors. On the misdemeanors, how are we going to do the reforms? I think when you sit down and you do the misdemeanor, you do the reforms, I think that's the first step. I think introducing to the reforms on the misdemeanors, I think at that moment in time, having everybody in the room together and talk, that dialogue will allow the individual to say, you know what, we can also kind of go over here in the same direction with some of the felonies. Because I think what we have to sit down and do is, one, you have to understand there has to be clear and convincing evidence. When you have a standard, that's what attorneys understand. Because to find you guilty in a jury trial is beyond a reasonable doubt. You know, to arrest you is probable cause. There you have clear and convincing evidence and everything right here in the middle. So I think once we have the standard, then we can work from there. But you first start with the misdemeanors and then the felonies. You have to understand this is the standard in terms of the initially going in there and saying what the bail should potentially be or not be. I think once we get there, you're talking about a standard that attorneys understand. Because what happens too often is that you have Joe Blow mad at Joe Blow, they run down, they take out charges, and they're using the criminal justice system. I'm a poor guy, he broke up with the wrong young lady, and she's taken out 7 or 8 charges against him. As soon as we win one, then she takes out another, then another, and another. And the problem that you have is, there's so many people in the system. But eventually, if we could just say, okay, this is a misdemeanor and this is what's going on, and you would look at it from a different point of view. Like for instance, she takes out charges because she says he keyed her car, he destroyed her door. Well, I mean, that's the automatic recognizance. You know, you're automatically going to be released on that. But the system says, oh no, you have been charged with keying her car before, you've been charged with harassment before, you've been charged with trespassing before, we're going to set you a $45,000, $50,000 bail. That to me makes no sense, especially when I can show everything else. But I think if you can focus on the misdemeanors, you focus on the clear and convincing evidence, then I think we have the ability then to sit down and have meaningful discussion about bail reform and dealing with some of the more violent offenses to say just because they are charged with an attempt murder or first degree assault, there must be other things that we look at. For instance, what is the evidence that we're looking at? Did you recover a handgun? Were they arrested at the scene? Do you have photo arrays? Or do you just have someone saying, look, okay, they shot at you. Did anyone call 911 to say that there were shots fired? There's nothing there. There are no shell cases. There are no bullets. There's nothing there. Then as a judge and as the state, they need to be able to sit down and look at their case differently. But right now, the state's looking at the case based on the charges.
Thank you all. Frankly, my questions have been asked. So perhaps though, I do have one. I've heard areas of agreement. I've heard areas of disagreement. And just if you were to just sum up very succinctly, very shortly, the one area, the one thing that, because both of you were here during the previous panel, what is the one, maximum 2 items that you think that you most agree with that you heard? And then where do you see your fundamental disagreement? And again, just concisely, simply, to the extent possible.
I think we fundamentally agree that the courts and judges should not say a person is dangerous because of the charges, I would say. I think the judges would sit down and need to look at the larger picture. And just the charge itself, I think that's one of the places that we agree. I think where we disagree is that I think wanting to get rid of money bail altogether. I understand some people can, some people can't pay, but I believe that a lot of that, you sit down and talk to the attorney, let the attorney speak with their client about what they can and can't do, and put together a package that allows them not to be strained financially. And that's what I believe is just in terms of where we are.
Thank you.
I agree with Ivan that, well, I agree with preventive intention needs to be properly defined. And again, that's because of concern that bring this panel, which is civil rights concern. Freedom cannot be just denied without a standard proof and certain procedural protections and evidentiary protections. Again, in this realm, in this life, I agree with that. I also agree that there's probably some way to properly look at low-level, non-violent, where those folks fit in, and how do those folks fit in the system. I think that the solution that will baseline supports that policy change is going to be data collection, which I think has been done poorly across the country on this one. There's a study from John Hancock College that supports that. Where I think we disagree fundamentally, and echo what I said, is that most bail reformers believe that there is no place for money bail, and whether they want to admit it or they want to point to the rule and say the rule preserves money, yes, it does, but look at how it works for those it works for, and figure out a solution to those it does not work for. Mike American has the success he does in St. Mary's County because he lets it work for those it works for, and he helps those it doesn't. And that's true. If you want true progress, he's the example we're going to steer by. Listen to what he said.
Thank you. So we're beyond our time. I think that, thank you for your contributions and thank you for taking the time to speak. This has been a full day of questions, a full day of information. Thank you to the panelists. I would like to ask the committee members if you could please stay after folks depart so that we can have a debrief of ourselves. Okay?
Thank you.
Thank you. Thank you.
Sorry for using your name, Ms. Bennett.
No, she's in the front. She's.
I can't do that one.
Barbara, you said the record remains open
30 days.
30 days.
But this is open to the public, you're welcome to stay. In fact, stay. In fact, stay.
We're just not gonna take any more discussion.
Got it.
You're welcome to stay.
It's a long story,
Yeah, so I guess that's where our observation, yeah.
Oh, me too. Man, turn it off.
Yes.
Going both ways, but there's a way to turn it off. Here we go.